Why do you want adjournment?
Your Lordship, the panel for the company, the panel council is not present today.
Oh, okay.
So,
Okay, you're mentioning on behalf of Kim.
Lordship,
Penny.
Lordship,
Okay.
Lordship.
Learned Counsel, Mr. L. Pom makes a mention on behalf of the counsel for the appellant, Ms. Kim Penny, who has some difficulties today and prays for listing the matter on
2nd of April.
2nd April. So, praise allowed, list on 2nd April. Learned Counsel, Ms. such and such, Ms. Lucino appears for
Respondent number 4.
respondent 4 and Ms. Grace.
Respondent
Namki
1 and
appears
3,
for
Lordship.
respondent number 1.
1 and
List
3.
1 and 3, yes. List accordingly. Yes.
Lordship, I also like to mention item number 10, Lordship. Your Lordship, I am for the respondent. So we will be filing objection to the IA filed by the appellant regarding delay. So our objection is ready, but we have sent it to the company to obtain the signature. So 2 weeks may be given, Lordship.
2 weeks.
Lordship.
Okay, Learned Counsel, Mr. L. Pom, appearing for the respondent, submits that he would like to file an objection in the IA for condonation of delay and prays for 2 weeks' time to file the same. So, prays allowed, list after 2 weeks. None appears for the appellant when the matter is called. Stop. Yes.
Obliged, Lord.
May I please the Lordship?
Yes.
Lordship, I beg to mention item number 12. Lordship, kindly grant us 2 weeks time to file affidavit in reply.
To file reply.
Yes, Lordship.
Okay.
Also, this matter may be kindly be listed along with WPC number 204 of 2025.
Along with 204.
Yes, sir.
Learned Counsel, Ms.
Alitosu.
Alitosu makes a mention on behalf of the leading counsel and submits that they would like to file a reply to the counter affidavit filed by the state respondents and prays for
2 weeks
3
time.
weeks' time to file the same. So, she has also prayed that this matter may be listed along with WPC 204 of 2025.
203 of 2025.
No, this one is 203. This is 203
Yes, Your Lordship.
along with 204 of 2025. Stop. List accordingly after 3 weeks along with WPC 204 of 2025. Stop. Learned Government Advocate Mr. Tiba Pom is present. So, yes.
Much obliged.
Please, Your Lordship. Lordship, I beg to mention item number 16, Lordship.
16.
16 on behalf of Vijay Lordship. If this matter can be listed after a week, Lordship.
On behalf of
Vijay
Vijay
16.
Learned Counsel, Mr. Manchong Konglyak is present. Learned Counsel for the petitioner, Mr. Manchong Konglyak is present. Ms. S. Chang, Learned PP, makes a mention on behalf of Mr. Vij Momi, who's appearing in this matter and has some difficulties today to list when?
After a week,
To
Lordship.
list the matter after a week. Stop. Prayers allowed, list after a week.
Lordship, as
Interim.
directed by this Honorable Court on 6 February, to take the steps for service of notice upon respondent number 2 through the
Through the
concerned police station.
police station.
Accordingly, I have taken it on 9th. And the delivery confirmation was made on 12th. Accordingly, I filed the
You have filed
affidavit
it?
today morning.
Okay. It's okay. Let it be on record. List after 1 week.
Lordship,
There's an interim.
Yes, the interim order passed earlier shall continue till the next date. Yes.
Lordship, I have similar prayer for item 23 on behalf of Vijay Lordship.
Item 23. Item 23, who's for the appellant? None appears for the appellant when the matter is called. Ms. S. Chang, Learned Government Advocate, prays for listing the matter after a week.
After 2 weeks,
After
Lordship.
2 weeks, as the counsel, as the Government Advocate, Mr.
Vijay
Momi, appearing in this matter, is indisposed.
Lordship.
So, list after
For
2
the
weeks.
appellant, my lord.
Yes. Okay,
In
okay.
item number 23.
Okay. Learned Counsel, Mr. Such appears for the appellant. You delete that one, no? When I said that none appears. Okay. After 2 weeks, no?
Yes, Lordship. Much obliged, Lordship.
Much obliged.
May I please, Your Ladyship?
Yes, yes.
Your Ladyship, may I mention item number 25? This was wrongly listed today. So if this may be
25.
listed- Yes. Motion from the sub-ladies.
Yes. This should be before the division bench.
Division
actually.
bench.
Item 25, you just say list before appropriate bench. Okay.
Yes.
Much obliged.
May I please, Your Lordship?
Yes.
Your Lordship, I'll be appearing for respondent number 1 in this matter in serial number 18.
Serial
I'm yet to file my wakalat nama, Your Lordship.
for respondent number
1.
1. How
Kindly
much
give
time?
3
How
weeks'
much
time.
3 weeks. Learned counsel, none appears for the petitioner when the matter is called. Learned counsel, see, prays for 2 weeks or 3 weeks?
3 weeks, Your
3 weeks
Lordship.
time to file the vakalatnama as well as the objections on behalf of respondent number 1. So prayers allowed list after 3 weeks. Yes. Yes.
With this, Your Lordship, I beg to mention item number 8. I'm on behalf of Sir Imti Wapang.
Which item number?
8.
8.
Your Lordship, kindly list this matter on 30th of this month.
30.
Yes.
Yes. Learned counsel for the appellants, Mr. Medover is present. Stop. Ms. Sergeant Search makes a mention on behalf of Mr. Imti Wapang, counsel for the respondent claimants, to list the matter on 30/3/2026. So list accordingly. Yes.
Much obliged.
Lordship, I may be allowed to make a mention for admission items 2, 3, and 4. These are analogous matters. I have taken the consent of the United States Government Council as well. We are actively under negotiation, Lordship. The department has in principle agreed. However, due to the ill health, my client, he recently underwent heart surgery. He is unable to travel. So it may kindly be listed after, if possible, 6 weeks, my lord.
6 weeks.
My lord.
Learned counsel for the petitioner, Mr. Sentianger, submits that some negotiations are going on for an out-of-court settlement between the parties, and therefore prays that the matter may be listed after 6 weeks. Stop. Who's appearing? Government?
OMG, my lord.
Okay. Okay, just say prayers allowed, list after 6 weeks.
Deeply obliged, my lord.
May I please, Your Lordship? Lordship, I beg to mention item number 9.
Item
9.
9. Yes.
We have received affidavit in opposition. However, I'm yet to file my reply. So if Your Lordship may allow...
Affidavit in opposition
Yes, counter affidavit.
regarding condonation.
Yes, Your Lordship.
Okay. Learned counsel for the appellant, your name?
Medokiki.
Ms. Medo Kiki submits that an objection has been received from the respondents in the application for condonation of delay, and accordingly she would like to file a reply to the same and prays for
4 weeks time.
4 weeks time. Stop. List after 4 weeks. Yes.
I would also like to mention item number 6. Lordship, we are yet to make the 50% payment.
You're yet to?
Make the 50% payment.
Okay, there was a direction to deposit 50%.
Yes, Your Lordship.
When will you make? I think there was a time-bound direction. I think it was either 60 days or was it?
The company have approved the payment. However, we are yet to receive the check. So,
Yet to receive the check.
yes, Your Lordship.
Okay, so how much time? 2 weeks? 4 weeks?
Yes.
Why so long?
To reach here, the check to reach here, it takes time.
So where is the head office?
Kolkata.
The learned counsel for the appellant submits that they are yet to deposit the 50% of the awarded amount which was directed by this court, and it is submitted that she may be allowed another 4 weeks time to receive the check and to make the deposit. Stop. Learned counsel for the respondent, Ms. Lucine, is present. No objection? And has no objection? Stop.
No objection.
Yes.
Lordship, I for respondent 1 to 7.
Oh, okay. Mr. Sari for 1 to 7, Lucine for
Performer respondent.
former respondent. Okay. So, list after 4 weeks. Yes.
May I please?
Yes.
I'd like to mention item number 24 from the hearing list now. Lordship, here my senior people is indisposed to them alone. So I believe this matter can be listed after 2 weeks.
Who's appearing for the petitioner? Yeah, any objection?
No, no objection.
Learned counsel for the petitioner, Mr. Such and Such present. Please give your name. So, Mr. Meadow Vero appearing for the respondent. Which respondent?
Sole respondent.
Sole respondent submits that the leading counsel, Mr. P.P. Paul, is indisposed today and therefore prays that it may be listed
After 2 weeks.
after 2 weeks. List after 2 weeks as prayed for.
Much obliged, Lordship.
Full motion on the supplementary cost list, item number 26.
Yes.
My lord, Lordship is well aware that a single person cannot be convicted for criminal conspiracy. There must be a meeting of minds. There must be complicity. Now, here the facts in the gist is that CBI has filed charge sheet against the present accused. Charge sheet number 6 of 2021, which I have annexed, my lord.
This is that High Court case.
Yes. Now, no prosecution sanction was granted to any of the government officials. He is the lone contractor. And it is clearly reflected at page number 82, my lord, paragraph 16.32. This is the charge sheet which was filed by the CBI.
82.
Yes, my lord. Page 81, I'm sorry. 82 is the type copy. But 81 is also readable. 81, 16.32, if I may be permitted to read. However, the state government of Nagaland has declined to issue prosecution sanction orders against the accused engineers of NPWD, namely so-and-so, as conveyed by the Secretary to the Government of Nagaland Works and Housing Department, white letter number 10/12/2021, and hence they are not sent up for trial. Therefore, it is only the present petitioner, who is the sole accused who is being tried. Now, he is being tried under sections 120B, which is criminal conspiracy, and 420. Charges have also been framed. I have agitated.
No, but even if 120B is not there, 420 can be sustained.
Yes, my lord, my lord. So my grievance is that 120B may be removed because the line of cross-examination is going to be very different.
Is the CBI filing any application against this non-granting of
Your
the...
Honor, my lord, in that case, I have not received any instruction nor any idea whether against the decision made by the state government, any petition is filing before the court or
Before
they
the
are
High
taking
Court,
any further steps. I have no idea. But it is a fact that for 3 times they have sought the permission, but it was denied. So thereafter, the charge sheet was filed. And what my learned friend is saying, no doubt, though prosecution sanction was not been granted for the government officials, he's a private person. So he thinks that 120 does not arise. But what about 420? So at the time of the framing of the charge, he should have prayed that 120 should not be brought in. After that, after all, if it was brought in also, at the time of the argument, the court has to look into that aspect, and the petitioner, they are supposed to come to that extent, 420. But here, it is just a wastage of time before the Honorable Court that they want to just exonerate the section 120 before the Honorable Court and to send back for trial. I think that is if that is the intention, that it is not a wise move.
Let us see the prayer.
And before coming to the
132.
facts,
Page 132. This is the order by which I am aggrieved. Here it is clearly
Page
reflected that.
132, no?
Yes, 132. I have made submissions against the charge under section 120B.
Present for the accused and merely objected to this.
I don't remember, in fact, I don't remember raising objections on
framing charge under 420 IPC. But it has also been reflected. I made strong objections orally. Because since the days of Topantas, 1956, the law is well settled. It has not been disturbed. That for criminal conspiracy, there has to be at least 2 persons.
My lord, here, that is not the issue here. There were so many persons, government employee as well as the present petitioner. Only the thing is that the sanction was not granted. Sanction was not granted. Otherwise, the criminal conspiracy, let the petitioner prove before the trial court whether he is a locus to say that there is no conspiracy or not. But here, number of government officials has been supposed to be prosecuted, but just
but when the ingredient of 120B is not there,
Yes.
how can the charge be freed?
Yes, there is no prima facie case. It is legally
no,
impossible.
it is what my submission is that 120B with the private person is there along with the other state employees. But the only problem was that the state employees were not granted prosecution sanction just because of that. Otherwise, there is a relations of criminal conspiracy. That's what I'm trying to bring
Now,
in. But-
besides the other government employees, how many accused are left besides you?
Yes, this is the one in charge sheet number 6. And a similar situated case is before the Honorable Court.
Yes.
That is
Yes,
also
that is-
in the
that
same,
is a different charge
same
sheet.
Different one,
perspective.
different
Yes,
charge sheet.
different charge sheet. And
So
the
in
case,
this charge sheet, you are the only one.
yes. And different case number before the CPI court also. This case is CPI case number 1 of 2024. The other case is CPI case number 1 of 2025. The other case is charge sheet number 7. This is charge sheet number 6.
But
Here
the-
I am the lone accused.
And my lord,
And my lord, prosecution sanction has not been given. Way back in 2021, the law is settled that the maximum period is 4 months. 4 months has lapsed long time ago for grant of prosecution sanction. So
Okay, at this stage, we will just issue notice and then we will
stay the proceedings.
stay the proceedings.
Yes,
because
my
he's the
lord.
only one.
I have a strong objection in this case. Here, they have invoked 442 and 438. So that provision will come into play in this case or not? Because here, I'd like to take your lordship to
Filing
this.
as a revision petition.
Yes, so revision, but it is exclusively for certain specific sections as per the PNACSA. Here, 442 is a High Court power of revision. I may be allowed to read out, Your Honor. Clause 1. In the case of any proceeding, the record of which has been called for by itself or which otherwise comes to its knowledge, the High Court may, in its discretion, exercise any of the powers conferred on the Court of Appeal. Section 427, 430, 431, 432, or on the Court of Session by Section 444, and when the judges comprising of the Court of Revision are equally divided in opinion, the case shall be disposed in the manner provided by Section 433. So this present revision should come within the preview of the given sections. So whether in this case, it is, they are challenging
No,
the
but against an order of discharge or against an order framing charge.
framing charge.
Revision lies.
But here, revision for that, there is another scope, 529, 528.
that is
Which
inherent,
is for
powers.
inherent power, yes, very
That
much.
is inherent power.
That is inherent power, but here, if your lordship,
That
you kindly
is
refer to
quashing
427.
petition.
Revision lies, revision lies.
Quashing petition.
427,
But
sir.
revision lies in
But-
such
but
orders
here,
framing charge.
my lord, 427, because the sections cannot be read isolatedly in this case. 427, after perusing powers of the appellate court, 427, after perusing such record and hearing the appellant or his advocate if he appears, and the public prosecutor if he appears, and in case of appeal under 418 or section 419, the accused if he appears, the appellate court may, if it considers that there is no sufficient ground for interfering, dismiss the appeal or an appeal from an order of acquittal. This is very important. From an order of acquittal, reverse such order and direct that further inquiry be made or that accused be retried or committed for trial as the case may be, or find him guilty and pass sentence on him according to law. Clause B, and in appeal from conviction, reverse the finding and sentence, and acquittal or discharge the accused, or order him to be retried by the court competent jurisdiction subordinate to such appellate court or committed for trial. Or clause 2, alter the finding, maintaining the sentence. Or clause 3, with or without altering the finding after the nature or the extent of the sentence, but not so as to enhance the same. C, in an appeal for enhancement of sentence. So all these are the, and again coming back to this 430, my lord, 430, suspension of sentence pending appeal release of appellant on bail. So these are the provisions under which 442 can be exercised. But here in this petition, in this case, it is in connection with the framing of a charge. Framing of a charge.
That 427, this is the appellate power.
Appellate power.
This is appeal.
But here
whereas this is revision.
Revision.
442 is revision.
Yes. So under revision, the clause is very clear. 442 cannot
Because-
be read out isolatedly, leaving aside the clause
Because
sections of
appeal
law
can be
given.
only against acquittal or conviction.
Yes,
Or
against the
for
final order, yes.
enhancement of
Yes,
sentence.
then coming to other provision also, my lord, because here under 442, 5 specific section has been given where the revision can be exercised. No,
Okay,
430.
we will record your objections
Yes.
and then we will hear it finally. That will be open, that will be kept open. Okay. What is 438?
438 is also a
397, formerly 397 CRPC.
Oh, okay.
442 is 401 CRPC.
Yes. Okay. The instant application under section 442, read with section 438 of the BNSS, has been preferred against the assailing the impugned order dated 5/12/2025, passed by the learned Chief Judicial Magistrate Dimapur, by which charges were framed against the petitioner under section 120B and 420 IPC. Stop. Arising out of CBI case number 1/2024, corresponding to CBI case RC2, you just see from the cost title, okay, 2019 under section 120B and 420 IPC. Stop. Heard learned counsel for the petitioner as well as Mr. Pendang Wapang, learned PP for the respondents. Special PP, no?
Yes, madam.
Special PP for the respondents / CBI. So the case of the petitioner herein is that the CBI, after conducting investigation, had filed a charge sheet being charge sheet number 6/2021, dated 17/6/2019.
No, my lord.
No, sorry.
This is 30/12/2021. 17/6 is the date on which FIR was filed.
Okay.
FIR was registered.
Okay, so charge sheet is
Last page.
dated
30/12/2021,
30/12/2021.
my lord.
2021.
Yes, my lord.
30/12/2021 against the petitioner and how many others? Against
Four
the petitioner
others, but-
and 4 others.
The rest are state government
Yes, and
employees.
4 others. Stop. It is stated that the other co-accused are all government employees, and the petitioner herein is a contractor. Stop.
I'm sorry, my lord, and 3 others, my lord.
3 others.
Including the petitioner, there are 4 accused,
Okay,
yes.
and 3 others. Stop. However, the government of Nagaland has declined to issue prosecution sanction orders against the other three government employees slash accused persons. Stop. And hence they were not sent up for trial. Stop. It is further, it is also submitted by the learned counsel for the petitioner that during the hearing on the framing of charge on 15/12/2025, the counsel for the petitioner had objected to the framing of charge under section 120B IPC, since there is no prosecution sanction against the co-accused government employees, and that the petitioner, being the sole accused, cannot be charged for criminal conspiracy. Stop. However, the learned trial court has not taken the submission into consideration and has framed charge against the present petitioner under section 120B as well as section 420 IPC. Stop. Being aggrieved, the petitioner is before this court. Stop. Issue notice, issue notice, returnable in 4 weeks. Stop. Call for the records from the Court of Chief Judicial Magistrate, Dimapur. Stop. Since the learned special PP has accepted notice on behalf of the respondent, no formal notice is called for. Stop. Till the next returnable date, the proceedings of CBI case number 1 of 2024 shall remain suspended. 1 of 2024, isn't it?
My lord, before the learned CJM Dimapur.
Pending before the learned CJM Dimapur shall remain suspended. Stop. The learned counsel for the the learned special PP has also raised preliminary objections regarding the maintainability of the present application under section 442, read with 438 of the BNSS. Stop. The said objection is kept open, and the said objection regarding the maintainability is kept open and shall be heard at the time of final hearing. Okay. List of
My lord,
rules.
for the convenience sake, there are other 3 revision petitions of a similar situated case. That is also almost in the same angle. Though charge sheet number and case number is different.
Okay.
That is also in inclusion of 120p only.
No.
Yes.
No.
Those are also
yes.
pending.
Yes,
Yes.
it is also pending. It is also pending. But
On
the
27th,
legal grounds are totally different. There, I am saying that with the prosecution against me is groundless, and that it deserves to be. I deserve to be discharged. The case against me deserves to be closed. Here, I am only agitating section 120p. I am not agitating 420 IPC.
no, here,
Yes.
Here.
another
Yes.
one.
Another one, I am agitating all. I am saying that the case against me is groundless.
On that day, I was absent, but I was
You
not
have received
present.
the petition.
I've received the petition and necessary instruction has been sought, but I was in the presumption that.
Okay, so it cannot be clubbed up.
No, it cannot be clubbed. Yes.
Okay.
Deeply obliged, my lord. Much.
For admission, item number 1.
May I please, my lord? Lordship, in this matter, I am representing respondent number 2 and 5.
Yes.
Lordship, I have filed an affidavit showing the steps taken by me. Lordship, it was placed before the MRC by notifications, memorandum
Respondent number
2 and 5, my lord.
2 and 5.
Yes. So for the creation of 18 posts of supernumerary posts of work charge employees, a memorandum was prepared and it was placed before the MRC by a memorandum dated 1 of 9/2025, which is at page 13, your lordship, of my affidavit.
Yes, creation of 18 supernumerary posts of work charge employees under PHA and utilization of those who have completed 30 years of service. Okay, this is the cabinet memo.
Yes, your lordship.
So it is still pending before the cabinet.
No, this is not a cabinet member, your lordship. This is for MRC.
Oh, MRC.
Yes.
Okay.
Now, Your Lordship, this 18 post was placed before the MRC, and I have asked the up-to-date information with regards to this office memorandum. Lordship, I have received a letter dated 5/3/2026, wherein a document is annexed, which shows that the MRC has rejected it again, Your Lordship. Rejected it, Your Lordship. And therefore,
How many petitioners are here in this case? 18.
No, only one, my lord. Only one, my lord.
Then in that case, the others are not involved in this case, isn't it?
No, the others are
This
not involved.
17.
No,
other
17 are not involved.
Then in that case, why can't you move this petitioner's case alone? Because here they are facing contempt.
Yes.
They have to remember.
Yes, correct, Your Lordship. However, Your Lordship, it is in the phase-wise manner as per the office memorandum. So it has been sent in the phase-wise manner as following the complying with the office memorandum. However, the MRC has rejected it, and then the department is again re-preparing, Your Lordship, to be submitted before the MRC again.
You segregate it, because if it keeps on going like this along with all these 17 others, nothing will happen. At one go, they will never agree to creating 18 supernumerary posts. Never.
Lordship.
Okay. So if the petitioner's case alone is considered, then saying that this is a different case as the officials are facing contempt, then in that case it can be considered.
Your Lordship, in fact, Your Lordship, as per this letter, they are taking steps for resubmissions to the MRC. If I
No,
may be placed.
resubmission, okay,
Yes.
but still then, if they are submitting all these people again
Yes, my lord.
together, then it will face the same fate.
Lordship,
Yes.
Lordship. Lordship, that can
Let's
become,
see.
yes.
Because creating 18 supernumerary posts at one go,
Yes, my lord.
that is not possible.
However, Your Lordship, these posts are to be regularized as per the office memorandum, Your Lordship, 17/3/2015.
No, that can be done phase-wise.
Yes, and in the phase-wise manner, Your Lordship, this batch of people, this batch of road charge employees are being sent. Your Lordship will find the MRC not recommending it on the last page. On the last page, Your Lordship. The top one, creation of 18th supernumerary post of road charge employees under PHE department and regularization of those who have completed 30 years of service. Your Lordship, not recommended.
The department has not complied with the earlier directive of MRC. What was the directive?
Your Lordship, the directive, Your Lordship, will find it in my affidavit in opposition, Your Lordship, at page 10. Page 10 of my affidavit in opposition, Your Lordship, the last para. Only one post was regularized, and for the other 18, for the remaining posts, the department is asked to re-examine whether due procedures was fulfilled in respect of all the work charge employees and resubmit the proposal with strong justifications. This was what the MRC meant by this.
The direction was to consider or to regularize.
I think, Your Lordship, to
Let's see.
to take necessary steps and appoint and issue the appointment order of the petitioner within 6 months. Your Lordship will find it at page 11, para 9.
Should take further necessary steps and issue the appointment order. Appointment order. Why appointment order? It should be
It should be
regularization.
regularization order, correct, my lord.
And issue the regularization order within 6 months. Okay, that is a so clear direction to regularize, not consideration.
Yes, my lord. So some time may be granted, Your Lordship, to us. We are taking all steps, possible steps, Your Lordship, to comply with the order of this court.
Okay, we'll give them some time. Since substantial compliance is there, it's not that they are sitting over the matter. Learned counsel for the petitioner, Ms. Such and Such is present. Stop. Learned counsel for respondents 2 and 5, Mr. N. Nangami, submits that after filing of the affidavit in opposition on behalf of respondent number 2 and 5, he has received communication from the department, from the
Secretary, Your Lordship.
from the secretary to the government of Nagaland, PHE department, stating that letter dated 5/3/2026, stating that the MRC had, where is that? MRC had not recommended, MRC had not recommended the creation of 18 supernumerary posts of work charge employees under the PHED, among which the petitioner's post was also included. Stop. It is stated in the letter that the case of the petitioner, along with other similarly situated employees, is presently under process for resubmission before the MRC for reconsideration. Stop. It is also stated that the MRC had directed the PhD department to comply with all the directives as was issued on earlier occasion for putting up the proposal for creating the supernumerary post. Stop. Learned counsel therefore praised that the respondents respondents have been diligent and have been pursuing the matter till date. However, some more time is required before the final regularization order can be issued. Stop. He therefore prays for how much time?
4 weeks time, Your Lordship.
Therefore prays for 4 weeks time to comply with the direction of this court. Stop. This court is of the view that there has been substantial compliance of the direction passed in the order dated 26/9/2023, passed in WPC 187/2022, as the respondents/condemners have been actively pursuing or processing the case of the petitioner. Stop. Accordingly, list the matter after 4 weeks. Yes, much obliged.
I'm deeply obliged, my Lord.
For admitted, item number 5.
Mr. Lordship.
Yes, yes.
Lordship, on the last occasion, DCR record we called for.
Yes.
Whether the same as
Trial court record has come. No. Learned counsel for the petitioner. You're for
I'm
the
for the
peti-
respondent number
Okay,
one.
okay.
I'm for the petitioner, Lordship.
Learned counsel for the petitioner, Mr. A. Nikato Wotsa is present through VC. Stop. Learned counsel, Mr. Chingong Kongyak is present for the respondent number 1. The trial court records had been called for from the Court of District and Session Judge Zenipoto by order dated 17/2/2026. However, the same has not been received till date. Stop. The registry is directed to issue a reminder to the District and Session Judge Zenipoto to transmit the scanned copy of the records of civil suit number 1 of 2024. So list after 3 weeks.
Lordship, the matter was suspended, Lordship, till the next returnable date, Lordship. So if it may be extended, Lordship, the suspension.
The interim order passed on 17/2/2026 shall continue till the next date.
Obliged, Lordship.
For admitted, item number 7.
May I please, Your Lordship?
Notice.
Yes.
Okay, you have filed the affidavit.
Lordship.
Learned counsel for the petitioners, Ms. Grace.
Lordship.
Yes.
If this matter can be listed for admission hearing.
Okay.
On the last occasion, by order dated 24 Feb 2026, 2 more weeks were granted to enter appearance.
Have we called for the trial court records? Trial court records will be necessary, I think, no? Hasn't come, no? Learned counsel for the petitioners, Ms. Grace Namgi is present. Stop. Learned counsel, Mr. Nangsang Iyer appears for respondent number 2. Stop. The petitioner has taken steps by Dusty for service on respondent number 1, 3, 1, 3, 4, 5, 6, and 7. And the compliance affidavit regarding service has been filed on 21/2026. Stop. Accordingly, the notice on respondent number 1, 3, 4, 5, 6, and 7 is duly served. Stop. However, none appears for the said respondents when the matter is called today. Stop. Will the trial court records be required? Is it necessary? On which notice. Call for the trial court records from the court of
Civil Judge Senior Division.
Civil Judge Senior Division, Mokokchung, Nagaland. So list after 3 weeks for admission hearing. Yes.
For admission, item number 13.
Yes.
Your Lordship, the respondent yet to file the counter affidavit.
Who's appearing? Government? Counsel for the petitioner, Ms. Such and such present. Mr. Enangami, Leonard Senior Government Advocate is present. So it is submitted that the state respondents are yet to file the affidavit in opposition. So the learned government advocate therefore prays for
3 weeks
3 weeks time to receive instructions and to file the affidavit in opposition. So list after 3 weeks.
For admission, item number 14.
Your Lordship, same order.
Same. Okay, same order after 3 weeks.
For admission, item number 15. For orders.
Yes, my lady, the service of respondents are still awaited.
1 to 7.
My lady, if they can come up after 2 weeks.
Learned counsel for the petitioners, Mr. Fosiko Forte is present. Stop. Office note dated 11/2/2026 indicates that the return service report on respondent 1 to 7 is still awaited. Stop. In the meantime, the trial court records have been received. Stop. List the matter after 3 weeks awaiting service report on respondents 1 to 7.
Yes, my lady.
For orders, item number 17.
May I please, my lord?
Yes.
Lordship, I've been informed that this matter is handled by Ms. Livika. She is appearing for all the respondents, I'm told. Lordship, if 3 weeks' time can kindly be granted to receive the necessary instruction.
Learned counsel for the petitioner, Ms. Such and such is present. The learned senior government advocate, Mr. N. Nangami, submits that Ms. Livika has entered appearance on behalf of all the respondents. He therefore prays that the respondents may be allowed 3 weeks' time to receive instructions and to file affidavit, as Ms. Livika is indisposed today. So, at least after 3 weeks.
I'm obliged.
For hearing item number 19 to 22.
Lordship, I'll take your lordship to
These are what, analogous matters?
Yes, yes, analogous. All these stem from the same foundation, your lordship. All these cases. So I'll take your lordship to my WPC 88. Yeah.
WPC 88.
Yes, this encompasses all the other petitions. Here are all the facts in the other cases, which are also challenged in the other cases, are incorporated here.
So that means if this is decided,
Yes,
then
all
the
those, all
others
those are
will
yes,
follow.
yes. Now, your lordship, this the brief facts of this case is that way back in 1971, the petitioner's father was allotted a chunk of land in visit area by the then administration for his services to the public. In 1974, unfortunately, he expired. Then subsequently, encroachments, one after the other, from various individuals as well as the government also started granting the land allotted to his father. The petitioner was pursuing it with the government, and finally, in 1996, the then chief secretary directed the deputy commissioner to make an inquiry and instructed him that this is an action done by the government, and the administration must honor the previous administration's decisions and all those things. These encroachments, if it is true, it is not proper. So an inquiry be conducted. Nothing was done. The petitioner approached his honorable court by way of a writ petition, which was WPC 204K of 2012. And in that, this honorable court also came to the conclusion that yes, the petitioner has rights. So, as per the then chief secretary's direction, an inquiry be conducted. So now, from there, the inquiry started metastasizing. The government is now backtracking. They are saying that it was land allotted. Now we can take it back. That is their stand. So I'll take your lordship to the first annexure. This is page 29, annexure A, your lordship. This is the number of people who have given land for setting up the digit circle. This is 15th of November 68. So we, the undersigned, ANGs, GBs and members of digit circle desire and agree to change the name of the circle to digit circle from today, and thereafter do hereby willingly. Your lordship, the type copy is the next page.
Page 29.
Yes, page 20, page 30 it should be.
No.
Oh,
It's
your
page
lordship.
29 is a type copy.
Oh,
We, the undersigned ANGs, such and
Yes,
such.
yes. Willingly consent to locate the circle headquarters in a suitable place and digit area. We further objection from any source on this regard should be entertained. Necessary land required for the HQO will be given without objection. So land from these various ANGs. Yes, preaching.
Actually, in
We
our
had-
copy, the type copy is page
filed
30.
a rectified copy, your lordship. A
In this,
rectified-
in the court's copy, it is page 29.
Yeah.
We don't have the copy.
But anyway, your Lordship, I'll take your Lordship to the next page, that is a special permit. And the type copy is in the next page. So here in mine, it is 31, but in this court's copy, it will be 30. 30 is the...
Special permit for farmland?
Yes, at Digit.
At Digit.
So this is by the then Deputy Commissioner Mon, TCK Lota. Now, special permit for farmland at Digit, this is 29th of March 1971.
Yes.
Sri L. Wangshu Konyak, RCM is allowed to continue cultivation of the low-lying areas, which he has already put under paddy cultivation at Digit. The line of demarcation will follow as follows. A straight line will be drawn from a point on Sonari Mon Road as shown in the survey map till it joins another survey mark near the private track as shown in the survey map. From the survey mark point T, it will run straight south till the line reaches the first line of banana trees, after which it will turn straight northwest till it comes parallel to the point marked on the stem by me on 24/5/71. Taking the last point of northwest line, a straight line should be drawn towards south crossing the mark stem till it reaches another mark on the dead tree. From this dead tree, a line will continue straight for a few yards, then turn southeast and join the now Chum area. Following the area already chummed, this year a line should join Digit River near the pool called Jizak. Besides this area, he is also allowed to continue paddy cultivation at the confluence of Digit and dash pin shown in the map as dash. Besides these two areas, he should vacate all the areas he has put under cultivation immediately. So this is the permit.
Yes.
Now, the map is in the next page. Now, in
this Wangshu Konyak is the
is
petitioner.
the petitioner's father. Late. In 1974, he expired, leaving the petitioner a minor.
Okay, then?
Now the next page, page 35. This is Government of Nagaland, Office of the Circle Officer Digit, Mon District, Nagaland complained some encroachment was made by two individuals. That is, one is a Chief Ang of Chapoka village. Now he is the father of the present respondent number. They were recently completed, Your Lordship, only last year. Respondent number 5. Respondent number 5 is the present Ang. So his father encroached onto the land.
Acha, you filed an amended petition?
Yes, we have filed.
Where is that? Because in this, the R5 is not there.
Yes.
WP 88. Amended petition. Amended petition is kept in the file of WP 58. Page 35, yes.
Yes, page 35. So the present respondent number 5's father, he encroached onto the land. Now a complaint was made before the then circle officer, and the circle officer has given this decision. This is dated 11th April 75. So if I may read, Your Lordship. Whereas complaint has been received from GBs and Angs as well as public of Yongnu village like Sri Nokzam Konyak, Chief Ang of Chapuka village, and Sri Tingpong Konyak, GB attached to the circle officer's office, Tizit have encroached the land allotted to late Wangshu Konyak at Tizit headquarters, and now holding by his eldest son Sri Nokman Konyak. White the then Additional Deputy Commissioner Mon, Special Permit Memo number so and so, dated 29 March of 1971, under the signature of TCJ Lotha, IAS, and the then ATC Mon. I have personally verified the boundaries and shown in the said permit with the help of Sri Jiwang Konyak, TB, and Sri Achok Konyak, TB, in presence of the said holder and the GBs and armed and public of Yano village on 11 April 1975, and found bamboo groves, banana trees, stump of a dead tree, papaya tree, grown prominently in the said boundary. Therefore, I do not find any reason as to how Sri Nokzam Konyak and Sri Dingbong Konyak can claim the land by encroachment. I therefore uphold the special permit issued by the erstwhile Additional Deputy Commissioner Mon, and further allowed Sri Nokman Konyak, son of late Wangshu Konyak, to cultivate the whole plot of land as allotted to his father under the present care of Sri Zani Konyak, who is closely related to late Wangshu Konyak and resides at his headquarters, since Sri Lokman Konyak is reading in school at Mon. But in no case Sri Dani K can claim ownership of the land. As also, Sri Nokzam Konyak and Sri Dingbong Konyak should stop encroaching the said plot of land immediately in order to avoid further complications. So, the Deputy Commission, the circle officer upheld the land grant, the grant given to the petitioner's father, and then directed that no encroachments should be made. Now, what happened was, subsequent to this, in the early 80s, the present respondent number 5's village allotted some land. Now he is trying to conflict the subsequent allotment with this present allotment, which I am holding. This is the case. Now the next page, this is Subdivisional Officer Civil Visit. This is dated visit the 18th July 81.
Page 37.
Yes. This is with regard to the present respondent number 5's village, giving land on a compensation basis. This has nothing to do with the land which I am holding now, Your Lord. This was way back in 1968. Land was given by the villagers, and the petitioner's father was allotted the land. Now, in the process in 1974-5, the present private respondent number 5's father and another person tried to encroach, they were prevented. Now here, this is a letter in 1981, where the 1,200 acres of land was offered by the present respondent number 5's village on compensation basis, comprising land from the river towards the guest house. It is, however, found that Sri Nokman Konyak, son of late one, they are now convoluting everything and then bringing all these things together. It is, however, found that with Nokman Konyak, son of late Wangshu Konyak, and Dingni ex-MLA are still having cultivation in the given area. Your Lordship. Sri Lokman has also put up a case of his having ownership right on the straight permit issued to his late father. This office has not received till date any case of claim from Sri Dingni, though asked to intimate if there is any. In the event of misusing land now held by these two persons, the land offered by Jabuka village does not amount to 1,200 acres. As such, a visit town settlement development program before clarifying the said two locations. I therefore request that a point be made from your end to clarify Lokman's case, since a permit in favor of late Wangshu was issued from Mon's office. So,
Okay.
in the 80s only this, they were offering the land. And now they try to include the land which is now occupied by which was given to my father and occupied by me as part of that 1,200 acres. Now this is then
Given by Japuka village. Japuka village is the village of R5.
Yes, respondent number 5. Here's the Ang. Now, choose
Okay.
Now, Your Lordship, page 38. This is a complaint which was, so many complaints were written by me because of encroachments every now and then. Now, forwarding of complaint petition. This is addressed to the Additional Deputy Commissioner Digit from the Office of the Deputy Commissioner Mon. I have, this is dated 9th of March 94. I have the honor to forward herewith a complaint petition along with copy of the permit lodged by Sri Nokman Konyak of Digit Town in connection with allotment of site permit within his patty farm. Therefore, you are requested to examine the facts and issue eviction order as an early date. So, here also, encroachments were made. The ADC directed the DC directed the ADC to examine, and if it is true, to evict the people who have encroached. Now, the foundation of my present petition starts from this, the main foundation, the scope of the present case is laid down in this present Annexure F. This was written by the then Chief Secretary.
Okay.
Page 40 and the type copy is at page 42, Your Lordship. The type copy I'll read. This is 18th of July 1996.
18/7/96.
Yes. This is Office of the Chief Secretary. If I may read, a representation has been submitted to me by L. Nokman Wangshu, son of late Lokten Wangshu, alleging that illegal encroachment has taken place in the land given to his father, which he has inherited. This special permit for farmland at Digit was given to late Lokten Wangshu, the then RCM, and the area given to him was properly alienated. In course of time, encroachments had taken place by police department, industry department, and also by private individuals through permits given by administration at different times. The land given to late Lokten Wangshu, the then RCM, was in recognition for the assistance he has rendered to the administration and also for standing for the people in times of difficulty. In fact, without his consent or his successor, no land should have been allotted to any person or government department. It appears that no respect was shown to the permit holder who was given the farmland by administration for recognition of his services given to the government and the people. Even the Angs of Digit area had consented to this, as the land falls within their jurisdiction. The administration should always honor the commitment given by previous administration to keep its image in the eye of the people. Instead of protecting the privilege given to certain distinguished persons, if the administration allows encroachment by individuals or government departments, it does not show any good images before the public. You are hereby asked to conduct special inquiry and submit detailed report comment as early as possible. So the Chief Secretary's letter is very clear. Land was granted to the petitioner's father and it has been inherited by the petitioner. Nobody can touch it without the consent of the holder, that is the petitioner or his father. Now the petitioner's father is expired. And the Chief Secretary is reprimanding the administration. You cannot do these things. So conduct an inquiry and submit detailed reports. In other words, if there are any encroachments, then it has to be dealt with.
Okay. So after that, inquiry
After
was
this,
conducted.
since nothing happened, the petitioner approached his honorable court. I'll take your lordship to that judgment, which is at page 50. Page 50. Here in this case, the petitioner approached his honorable court, asking praying that the Chief Secretary's direction should be complied with.
Okay.
this was by Honorable Justice N. Chaudhary. Here in this case, the government has also filed their affidavit, Your Lordship.
Okay.
It's very clear. Government has filed their affidavit, they have no objection. They cannot raise any subsequent objections beyond what is laid down here. That is what I am emphasizing, Your Lordship. Judgment and order, this is dated 5/8/2014. Yes. The relevant paragraph, I'll take Your Lordship, the facts have already been dealt with as I have shown in the main annexures. Paragraph 5. Paragraph 4, from paragraph 4, if Your Lordship will see here. I have heard Mr. Subu Jamir, learned counsel for the petitioner, and Mr. K. Wotsa, learned senior government advocate, appearing for the state respondents. Number 5. The grievance of the writ petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. Thereafter, in the year 1975, the circle officer prepared a memorandum dated 11/4/1975, recognizing the same. If there is any encroachment, definitely, this is prejudicial to his legal and constitutional right. If there is any encroachment. The Chief Secretary of the State, being aware of the situation, issued direction to the jurisdictional Deputy Commissioner way back on 11/7/1996 for holding special inquiry. There is no reason as to why the Deputy Commissioner would not hold a special inquiry as directed by the Chief Secretary. Although detailed report after such inquiry was supposed to have been submitted before the Chief Secretary as early as possible, but the proceeding went hibernating without any valid reason, depicting irresponsibility on the part of the district administration. In the process, a proceeding before the Chief Administrator of the state has been stalled. Failure on the part of an authority in complying with direction of its superiors not only betrays inefficiency of the administrative machinery of the state, but has also potential of sending wrong signal to the society as to the rule of law, which is so sacrosanct in a democratic set of governance. 6. Although an affidavit in opposition has been filed on behalf of official respondents, the claim of the writ petitioner has not been disputed. They are now disputing it.
Okay.
In this case, the fact as to issuance of direction by the Chief Secretary is also not in dispute. This being the position, I feel inclined to allow this writ petition and direct the Deputy Commissioner, Mon, to hold special inquiry as was directed by the Chief Secretary by order dated 18/7/1996, within a period of 3 months from the date of receipt of certified copy of this order without fail, and forward the same to the Chief Secretary for passing necessary orders. The Chief Secretary shall pass necessary final orders within 2 months thereafter from the date of receipt of inquiry report from the Deputy Commissioner Mon. The petitioner shall forthwith furnish a copy of this order to the Deputy Commissioner Mon and shall get necessary acknowledgement to the body of the forwarding letter. With this direction, the writ petition is allowed. No order has to go. So the scope of this present case is encapsulated in this.
After this judgment.
Yes. It has to be based on this judgment and the letter of the Chief Secretary, the order of the Chief Secretary, which says that we have given this land to the petitioner's father, you cannot encroach. If there is clear encroachment, conduct and submit report. This court also is saying the same thing. So it cannot now metastasize into so many things.
This case was heard earlier.
It was heard by our learned honorable body, but it was discharged. He let go of it because on that particular day I had to go out of station. After the hearing started, actually more than a year has elapsed.
Then it was released.
Yes, and he released it because of my absence.
Because so many notes are there.
Yes, yes.
Yes, then.
So
come to page 54.
This is the, what I'm emphasizing is that the scope of this present case, it is predicated by this judgment. It cannot go beyond this. If any inquiry is done, what is the extent of the encroachment, if there is? to submit a report, and if there are encroachments, then appropriate order is to be passed by the authority. What they have done is, they have made an inquiry, so many several reports were submitted, and then all of them suggesting that we take the land away, we name a school or a building in the name of the father. And now, by the final order, the Home Commissioner has cancelled the allotment given to the petitioner. And that is what I am aggrieved with. My case is that no, the Honorable Court's decision and the Chief Secretary's earlier, it has to be based on that only. You cannot cancel my allotment. If the government were aggrieved, they ought to have filed an appeal in this particular case. They did not. In fact, they filed an affidavit. They admitted to everything.
Not disputing. They did
not
not
disputing.
dispute.
They have not disputed. They have admitted. No appeal was preferred by the government. And then when they are themselves not disputing in the affidavit, they cannot also file an appeal. Or even if they had filed the appeal, the appeal had to be heard on the basis of the affidavit only. So it would have led to nothing. So no appeal was made. So now this judgment holds the day. Now this is the annexure K is the imbued report, special inquiry report. Dated 31st October 2014, this was submitted, the covering letter is dated 31st of October 2014. That copy, it is smudged here and there, Your Lordship, so I have also enclosed the typed copy, which is at page 60.
Page 60.
Yes. The special, if I may read, Your Lordship.
1 minute.
It's a long one, but
Report. Yes.
the special inquiry committee was constituted White TC Mon number so and so, dated 2014. In pursuance of the Honorable High Court Kohima Bench judgment and order dated 5/8/2014, WPC number 204K of 2012. The special inquiry committee comprised of the following members. Now, the committee was initially given 45 days time to conduct a special inquiry of the given case and to submit a detailed report thereon. However, due to want of more information which required further survey of the area as exactly contained in the special permit, the committee sought to TC Mon for further extension of the time by 5 days till 1st November 2014 after several rounds of meeting, verification, examination of records relating to the case submits the final report. Background. In 1971, the then ATC Mon issued a special permit to let El Wangshu as farmland in recognition of his service given to the government and the people, White Office Memo number so and so, dated 1971. In 1974, Sri El Wangshu died and the special permission passed on to Sri Nokman Wangshu, the eldest son of late El Wangshu. Sri Nokman Wangshu alleges that despite having documentary evidence, the general administration has several times encroached upon his legally inherited farmland by way of issuing permits without his consent. In the same manner, in course of time, government department, including industries, other private individuals were granted permit by the general administration. As a background to the case, it is to be noted that the land for Dizit Township was donated by the Chapoka village, measuring 1,200 acres now. The donation was made to the government by the village free of cost without any terms and conditions, which was agreed verbally. No material evidence is available. This farmland also falls within the area donated by the Chapoka village. On cross-examination of the official records available in the office, This committee concluded that a special permission to be authentic. However, the extent of the area and boundaries as contained in the special issued White Memo number 29 March 1971. Though properly delineated during the issue of the special permit in 1971, the details of boundaries could not be traced by the committee members. But as claimed by the complainant, the special permission does not cover the entire areas south to Mount Sonari Road. To get a rough idea of the actual of the land, the committee decided to take a physical verification of the land with help of retired Tobashi, Sri Achawak and Mr. Zani, who were there even in the 70s. Their names are reflected in the 1975 caretaker of Mr. Nogman, who were present during the April 1975 verification. The physical verification was undertaken on 27/10/2014 with the help of the above named two persons along with Sri Nogman Wangshu. Even Sri Nogman, during his meeting with the committee on 24/10/2014, admitted that he has no knowledge of the exact boundaries as contained in the permit. The area, as shown by Sri Achawak, retired DB, and Sri Zanai, caretaker of Nogman in 1975, was surveyed with the help of GPS by the committee, covers a total area of 157.81 acre of land, which is very much within the DZ town jurisdiction headquarters. On cross-examination of office records on issue of permits, it has been found that in various stages and of officers at DZ, permits were issued by the authority concerned in the name of expansion of the town. To cater to the ever-increasing need of the fast population town government purely to meet the increasing need of the town DZ. All the above government departments, utility services are functioning today at DZ. On physical verification, it has been found that the district administration during various tenures of officers has issued 111 numbers of permit from 1988 till date. During inquiry, it is also found that the complainant, Sri Nogman, on his own capacity, had been selling out plots of land to private individuals as substantial areas without the consent and information to the government. Now, there is no need of the petitioner to ask for the consent of the government. It is his, as per the record. On further inquiry, it is also found that vast tracts of land have already been allotted, given away free of cost to several private individuals on several locations. It has been revealed that Sri Nogman, taking full advantage of the privilege given by government to his father for a farmland, has sold out plots to 12 identified individuals by taking substantial amount of money and later permits acquired by these Tonis from the ADC office TZ. Furthermore, due to his uncompromising stance between government and Nogman, several individuals taking of the situation has been occupying in more than 17 locations plots without any sanction from the government. All these are encroachers, Your Lordship. Committee finding. 1. The special permit issued in 1971, White Memo number so-and-so, 29 March 1971, issued by the then ADC Mon is authentic. However, there is no record of payment of revenue to the government, and the permit does not stipulate any terms and conditions governing the specification. Special permit. 2. It is an accepted fact that the land for Dizit Down was donated by Chapoka village to the government, and the special permit itself was issued to late L. Wangshu by the government. In view of the rapidly growing population of Dizit Town, the district administration needs more land for development of the town to appease the growing need of land for dwelling units. The district administration have issued permits for the purpose of expansion and development of the town. There are already 111 numbers of permit issued by district administration from 1988 till date. Further, 12 numbers of plots were settled through the complainant and 17 numbers without any permission, adding up to 140 families already settled in the area. Trying to relocate these 140 odd families will create a lot of social tension, leading to a grievous law and order problem in the town. 4. The committee is of the view that to bring an immediate and amicable settlement to this issue, an alternative arrangement may be offered to Sri Nogman Wangshu by offering him 200 by 300 square feet. This is the suggestion of land presently occupied by him, and also in recognition of the services rendered by his late father, L. Wangshu, either a school or public hall in the locality be named after him. Further, during the course of the inquiry, the Special Inquiry Committee has received a complaint letter from the Village Council Chaboka, which are made available to you in original, as the committee has no legal obligation in replying to these complaints. The Special Inquiry report is submitted to the Deputy Commissioner Mon for perusal and further necessary action. So this report was submitted. Then subsequent to this again, so many reports submitted by the department. But this is the main report, based on which all the other subsequent whatever reports were subsequently submitted to the government by the DC. The learned government advocate will also be presenting all those things.
Why so many reports?
I don't know, Your Lordship. They will have been. This court's order is very specific. Conduct a special inquiry, submit it, so that appropriate action is to be taken. But they have been submitting so many reports. Page 67 is one of them. Your Lordship. A report of the meeting held with Sri Nokman Wangshu, son of late L. Wangshu, in connection with special land permit dispute related to WPC number so and so, Sri L. Nokman Konyak versus State of Nagaland and others. So here they try to take away the land and then ask him that we will name a school in your father's name, and then we will allow whatever you are now possessing to be yours. All those things were going on. He refused, Your Lordship. As simple as that.
But how do you know the exact measurement? Because in 71, when you were
Yes.
given that land,
Yes.
the measurement was made, but then it was like some plant here, some
Yes,
tree
yes,
here,
yes.
cut in the banana tree.
Yes.
So those things will not remain over the years.
No,
Everything
they
will
don't.
change.
They don't. But fortunately, when this special inquiry was conducted, those persons who had knowledge about the extent of the land, they were also examined, and now they have come to the conclusion. Here, what they have done is, so far as the report, that he has also some plots of land, the government has also allotted land on this particular
On
plot.
that plot,
All those things are clear. It is very clear. I am only concerned with government allotting land possessed by me, and also individuals who are forcefully being allowed by the state government. Even individuals have been issued permit by the government to settle on my land. Those are undisputed. Those are undisputed. My case is that how many are there? Kindly determine it from now on, don't encroach. Secondly, at least, since all these allotments were made illegally, I should be compensated to some extent. Reasonable compensation should be given to me. That was my only case. From the very beginning. I am not saying no, evict all these families.
Because at this stage that is impossible.
It is not possible to evict.
Yes.
But what I am asking is, at least determine the land and compensate me reasonably for now who are there, and then no further allotments. That is what I have been standing from the very beginning. I am not asking for their eviction. No. The next copy also report after report, Your Lordship, submitted by the ADC. But the crux is the same. The facts are same. I am holding on to my position. They are trying to convince me. All those things. So we don't need to.
What is this restraint order?
Now,
Order, page
Your Lordship,
72.
this is part of the WPC 58 of 2017, and then WPC 207K of 2016. I'll take Your Lordship to my main petition, where I have laid down the facts, specific paragraphs, if Your Lordship will, so that all these are cleared up.
In WPC 88.
Yes, WPC, specific paragraph. Paragraph 15. Paragraph 15. This is with regard to WPC 207 of 2016. Now, while all these things were going on, these imbued orders were issued, because of which I was compelled to approach this honorable court by way of two petitions. So now the first one is 207 of 2016, which is item number 20. 19, item 19. So item 20. Paragraph 15 will clarify that.
Okay, paragraph 15.
Paragraph 15.
Yes.
If I may read.
Yes.
That subsequent to the said meetings, the additional deputy commissioner issued 2 restraining orders. Namely, dated so and so, 15/1/2015, and restraining order dated 12/10/2016, notifying not to carry out any developmental works in the disputed area by any individual or groups until the final settlement of the cases by the Honorable High Court. Later, by vacation order dated 20/10/2016, the additional deputy commissioner directed 7 individuals who are well-wishers and friends of the petitioner, to whom the petitioner had allotted some portions of land to erect temporary houses with a view to enable their children to pursue their studies in DZ, to vacate the land. The petitioner therefore was compelled to prefer a writ petition registered as WBC 207 of 2016, imputing the aforesaid 2 orders, and this honorable court by order dated 7/11/2016 was pleased to direct that the persons whose names are mentioned in the vacation order dated should not be disturbed in their peaceful possession of the land until further order of the court. The WPC 207 of 2016 is pending disposal presently. So this is the fact. This is the crux of the fact. Petitioner had allowed several of his who are staying in villages to construct temporary houses so that their children can study.
In his land.
On his land,
On
yes.
his land.
And now the ADC decided to evict them by these imbued orders. This is how the petitioner agreed, has approached this honorable court to, by way of this 207. And the stay order is still in place, Your Lordship. Now, next one, paragraph 16.
16.
This is with regard to WPC 58K of 2017. That again, the Monian Union Tizit, having filed a case before the Tobashes court, Tizit, claiming as theirs a plot of land, which the petitioner had allotted to one Mr. Wongtun, a missionary. The TB's court by order dated 13/4/2017 directed Mr. Wongtun to vacate the land. The petitioner therefore preferred another writ petition registered as WPC 58K of 2017, impugning the order dated 13/4/2017, and this honorable court by order dated 9/5/2017 was pleased to suspend the said order. The WPC 58 is also pending disposal. So the earlier 2 petitions, they are part of this. I have at least the crux of the case. I have.
So both cases
Yes.
were the subject matter was that
Yes.
you had allotted land to these people.
Yes.
Within your land.
Yes.
And the administration had passed restraining order against them.
Yes.
So you challenged those.
Yes. And in the second case, that is the Monian Union, the administration allotted this union land. What happened was, without my knowledge, I had no idea that it was allotted. But so it so happens, Mr. Wangdun, who is a missionary, I had allowed him to build a structure on that particular plot where the administration allotted the land to the Monian Union. So what happened was that the Vashes, they decided to evict him and to allow the the union to construct. Now, after this stay order was, after this honorable court stayed those orders, what happened was this Moni union started continuing construction. So we had to file the contempt petition. Only after filing this contempt petition, which is also item 90. Item,
Yes.
Your Lordship, item 21.
COP 23.
Yes, yes. Only after this was filed, they stopped all construction.
Otherwise, the boundaries are not disputed.
Not disputed. I have no dispute regarding those things. The administration has already determined in the presence of people who had knowledge. Because at that point of time, I was a minor. When my father expired, I was a minor still going, admitted to school going minor. So one of my relatives was taking care of me. So his name has also been reflected here. So, and another Tobashi who was at that point of time alive, in 1974, the survey was done in their presence. And in 2014 also, since fortunately they were alive, they went to the spot and verified everything. So far as the extent of the area, it is not disputed. The only issue is how many allotments were given by the government to private as well as government departments. That is the only determination to be made, Your Lordship, as per this Honorable Court's order as well as the Chief Secretary's order, not the subsequent developments which they have tried to manufacture along the way. Because the foundation is those two only. You cannot go beyond that. It is not a cancer that can metastasize anytime. That is my case, Your Lordship. Now,
So your prayer is to set
Yes.
aside the inquiry
The-
report
yes, the
and
inquiry
direct the
report.
state respondents to pay land compensation to
Yes.
the petitioner for the area of land covered by 111 permits issued to settlers.
the last letter which came into my possession is at Annexure Q, Your Lordship. This is
Annexure Q.
Annexure Q. This is issued by the Home Department to the Deputy Commissioner. And then page 80, Your Lordship. Page 80, based on which I believe it is based on this or whatever, because these are the only records made available to me. So many letters here and there were issued, correspondences were made between the government and the TC's administrative officers. But all those, leave aside all those, what are available with me are these two. The impugned order, which is page 80, Your Lordship. First, page 80. Yes. This is dated 24th September 2018.
Issued by Home Department, Deputy
No,
Commissioner.
Deputy Commissioner. This is a substantive order. A letter was issued by the Home Department, and this is the order that was passed based on that. In pursuance to the letter from the Home Department, Government of Nagaland, white letter number so and so, dated Kohima, the 14th September 2017, with regard to special inquiry report on the special permit issued to let Wangshu Konyak farmland at district headquarters, the permit is hereby cancelled with immediate effect in view of the expansion and development of district administrative headquarters, requiring all vacant land for public office establishment. This is clearly contrary to the judgment of this Honorable Court in 204K of 2012, and also the Chief Secretary's order. It cannot be done in this manner. And by this letter also a direction is issued to this page 81. 25th January 2020. By this letter,
Which one? Page?
page 81, Your Lordship, the next page. This is dated 25th January 2020. From the Home Commissioner
To the Deputy
Principal
Commissioner.
Secretary Home to the DC.
26 January.
Yes.
This is 24th September 2018. Okay, yes. What does it say?
It also says directs the Deputy Commissioner to essentially issue an order which is page 80, Annexure D, the Tribune order. Now he is directing that those vacant plots not sold or given to private individuals are allotted through any permit, as well as paragraph 6. Those plots sold given to private individuals but vacant mentioned at serial number so and so, which measures so and so may also be taken over by the government. In all these cases, proper allotment orders in the manner as considered appropriate by you may be made, so that there is absolute clarity that these tracts of land belong to government. This is in clear contradiction of the judgment of this Honorable Court and the Chief Secretary's letter. And this is also issued by the Home Commissioner, the Special Secretary Home. These are arbitrary orders, which is not sustainable. It has to confine, all decisions has to be confined to the judgment as well as the Chief Secretary's letter. That is my case. So here in this case, all these subsequent orders which tries to take away the land from me are arbitrary and ought to be quashed and set aside. And that direction be issued to the government to at least allow me to possess the remaining portion, and also those plots which were allotted without my consent by the government, and also appropriate compensation should be given to me. That is my only humble prayer before this Honorable Court. Simple as that. Despite so many representation letters and all these things, it has to go all the way back to the 1986 order of the Chief Secretary and the direction of this Honorable Court.
Okay.
With that, for now, I will raise my submission. I'll allow the other parties, and if necessary, I'll.
Yes. You are not disputing the boundaries, isn't it? The boundaries.
No. We are not disputing the boundaries, Your Lordship.
Then in that case, if he is the owner, as stipulated in that special permit, then in that case, don't you think the government should compensate him?
No.
Why not?
He is not the owner, Your Lordship. He is claiming to be an owner. He is not an owner. Allah, Your Lordship, I'll satisfy my Lord. Your Lordship, one by one, Your Lordship, allow me to first take my Lordship to WPC 207. 207.
Yes.
This is the first writ petition, Your Lordship. 207 K of 2016. Your Lordship, the petitioner is impugning 3 orders here. Your Lordship will find that at page 13, 12 and 13.
C207.
Yes. Page 12 and 13. No, prayer.
Yes.
Prayer 1.
12 is the prayer.
Yes, prayer 1. Allow me to read this, my lord. Quash and set aside the impugned illegal restraining order 15/1/2015 and 12/10/2016 in the interest and for the end of justice. Your Lordship will find these 2 impugned order at page 35 and 36. 36. Now, Your Lordship, the second order that they are impugning is a vacation order. That is, quash and set aside the impugned arbitration vacation order 2010-2016. Lordship will find 2010-2016 at page, on the next page.
Page 36.
Yes. Vacation order.
Page 37.
Yes. Allow me to take my lordship to this vacation order. Here, this has been issued by the office of the additional deputy commissioner. And it says, Your Lordship, allow me to read this. With reference to the ADC TGIT order number such and such dated 15th of January 2015 and order number such and such dated 12th of October 2016 in connection with the Gauhati High Court Kohima bench against land dispute at the industry colony TGIT town. Whereas the following persons, Your Lordship, has been violated the said order of the High Court as well as the restraining order of ADC TGIT. So there are 7 names mentioned, Your Lordship. So the restraining order has been issued to these 7 individuals. None of them are here before this court. None of them. Neither in the writ petition, there is an averment made by the petitioner that they have authorized him to file this present writ petition. The person who is aggrieved, Your Lordship, are not here before this court. And the person who has not been issued an order is here before this court challenging that vacation order. Is this maintainable, Your Lordship?
No, what he's saying is, these people have been given allotment by him.
Yes. However, in order to challenge an order, an aggrieved person has to come before the court. None of the 7 individuals against which this restraining order is issued is here before this court, nor any averment is made in the writ petition stating that they have authorized him to file this writ petition on their behalf. And therefore, Your Lordship, this writ petition 207K of 2016 is not maintainable. Therefore, Your Lordship, I will not enter into any merit of the case that is there in this writ petition 207K of 2016, as it is not maintainable, Your Lordship.
Okay.
Now, Your Lordship, that takes me to 58K of 2017. Again, Your Lordship, you'll find the prayer portion at page 12 again, my Lord. at page 12.
Yes.
First prayer, Your Lordship, page 13. Quash and set aside the impugned illegal land permit dated 15/5/2011, which was issued without the consent and knowledge of the landowner's petitioner. And number 2, quash and set aside the impugned arbitration vacation order dated 13/4/2017 for the end of justice. The first prayer, Your Lordship, quash and set aside land permit dated 15/5/2011. There is nowhere in the petition which is where the petitioners annexed this particular impugned land permit dated 15/5/2011.
Okay.
It is not annexed. It is not annexed, Your Lordship.
Okay.
Now, second prayer, quash and set aside the impugned arbitration vacation order 13/4/2017. Your Lordship will find that at page 40. Now, Your Lordship, this is an order again issued by the Office of the Additional Deputy Commissioner. Allow me to read, Your Lordship, just the first para. May I read, my Lord?
Yes.
With reference to the complaint letter dated 23/3/2017 received from Monyin Union Tijit Town against Mr. Wandung Konyak of Nintong village for construction of the house at the allotted site of Monyin Union Tijit Town. In this connection, the DB's court Tijit summoned both parties to appear before the DB's court along with this site permit on 13th of April 2017. The Monyin Union Tijit Town produced site permit via number such and such, whereas Mr. Wandung Konyak could not produce the site permit. Therefore, the DB's court Tijit do hereby directed to Mr. Wandung Konyak of Niton village to vacate the house and removed the materials from the said site land on or before 13th of May 2017, that is within 1 month from the date of issue of this order. So this order was issued against whom, Your Lordship? Is it issued against the petitioner? No. This has been issued against one person called Mr. Wandung Konyak. Look at the cause title, Your Lordship. At page 2. Page 2. It's Mr. L. Nokman Konyak, the petitioner. The person against whom this order has been issued is not here before this court again. So this two-writ petition is defective, Your Lordship. It's not maintainable. The person who is supposed to be aggrieved is not here, Your Lordship. Therefore, Your Lordship, I do not need any submission to be made, particularly on these two-writ petitions, Your Lordship. They deserve to be dismissed on the ground of non-maintainability and defective.
Yes.
Now, Your Lordship, that leaves us with only one writ petition, that is 88 of 2022.
88.
Yes. Now, Your Lordship, the petitioner have taken my lord to almost all the documents. At the course of repetition, for a better understanding of my submission, Your Lordship, allow me to take back my lordship to some of the documents again, Your Lordship. I will start with page 32.
Yes, the special permit.
Yeah, now this is the basis on which the petitioner is claiming to be an owner of the land. And the first sentence submission that the petitioner used was, this plot of land was allotted to his father. Your Lordship, the word allotment is specific in meaning. So also the word permit is specific, Your Lordship. Allotment and permit, Your Lordship, these two are two different entities. It is not one and the same. Permit is, Your Lordship, permit is allowing something to an individual to do. And therefore, Your Lordship, this permit also allows the petitioner's father to do a particular thing. And what is that, Your Lordship? It is specified in the permit itself. Allow me to read.
Cultivation.
Yes, allow me to read the first para.
Yes. Please read.
Sri L. Wanshu Konyak, RCM is allowed.
What is RCM?
Regional
Council member. Okay,
Yes.
okay.
is allowed. See, Your Lordship, the word used is allowed to continue cultivations of the low-lying areas which he has already put under petty cultivation at Tijit. The line of demarcation will be as follows. So, the map that the petitioner is referring to is a map of that particular area where the petitioner's father was allowed to cultivate. This is not allotment, Your Lordship. This is not allotment. The sentence is very clear, Your Lordship. Allow me to just read this again, Your Lordship. Sri L. Wanshu Konyak is allowed to continue cultivation. Is allowed to continue cultivation of the low-lying areas where it's already put cultivation under petty cultivation at Tijit. So the line of demarcation now is mentioned in the first para. Allow me to read this, Your Lordship. A straight line will be drawn from the point of Sonari Mon Road as shown in the survey map till it joins another survey map near the private track as shown in the survey map. From the survey map point, it will run straight south till the line reaches the first line of banana trees, after which it will turn straight northwest till it comes to parallel to the point marked on the stamp by me on 24/5/1971. Taking the last point of the northwest line, a straight line should be drawn towards south, crossing the mark stem till it reaches another mark on the dead tree. From this dead tree, line will continue straight for a few yards, then turn southeast and join the now dreamland. Your Lordship, the next line is important. Following the area already zoomed this year, a line should join Tijit River near the pool called Chizet. Besides, see, Your Lordship, besides this area, he is also allowed to continue paddy cultivation at the confluence of Tijit and as been shown in the map. The last line, Your Lordship, this is important. Besides these two areas, he should vacate all the areas he has put under cultivation immediately. Is this an allotment order, Your Lordship? No. He has been, Your Lordship, by this permit, he is allowed a portion of the land for cultivation. And also at the same time, disallowed 2 areas where he was putting cultivation earlier. The last sentence, besides these 2 areas, he should vacate all the areas he has put under cultivation immediately. So these 2 areas was given to him for cultivation by this permit, and at the same time, by this permit, the other areas where he was putting cultivation, he should vacate. So this is not an allotment order, Your Lordship. This is not an allotment order. Your Lordship, who has signed this? Who has signed this, Your Lordship? It is by TCK Lota, Additional Deputy Commissioner, Mond. I'm using the name, Your Lordship, because
Yes.
I wanted to take my Lordship to a particular letter. Now, so my first point of submission, Your Lordship, is that this is not an allotment order. This is just a permit given to the petitioner's father to cultivate that plot of land which has been demarcated. Not an allotment at all, Your Lordship.
Okay.
However, Your Lordship, the petitioner now started claiming that he is the owner. He is the owner of the land and has submitted a representation to the Chief Secretary, to the then Chief Secretary,
Yes.
And the then Chief Secretary has brought out a letter dated 18th of July 1996, which Your Lordship will find it at page 40.
That one which was referred.
Yes. Allow me to read this again, Your Lordship. I wanted to point out something here.
Yes.
A representation has been submitted to me by L. Nogman Wanshu Konyak, son of late Longtang Wanshu, alleging, Your Lordship, see, look, alleging that illegal encroachment has taken place in the land given to his father, which he has inherited. The cushion, Your Lordship, when a permit is granted to a person, the cushion of inheritance, Your Lordship, will it arise? These are just, this particular para, Your Lordship, if you refer it, it is an observation given as per this representation submitted by the petitioner to the then Chief Secretary. Allow me to continue, my Lord. The special permit for farmland at Digit was given to late Longtang Wanshu. The then RCM and the area given to him was properly delineated. In course of time, encroachment has taken place by police department, industry department, and also by private individuals, though through permit given by administration at different times. The land given to late Longtang Wanshu, the then RCM, was in recognition for the assistance he has rendered to the administration and also for standing for the people in times of difficulty. In fact, without his consent or his successor, no land should have been allotted to any person or government department. It appears that no respect was shown to the permit holder who was given the farmland by the administration in recognition of his service given to the government and the people. Even the then Ang of Digit area has consented to this as the land falls within the jurisdiction. Your Lordship, here also the Chief Secretary is using, it appears that no respect was shown to the permit holder. Your Lordship. Then the next para, Your Lordship. The administration should always honor the commitment given by the previous administration to keep the image in the eye of the people. So he is asking the administration to keep the image, Your Lordship. His image. I would rather use the word his image because, Your Lordship, the then Chief Secretary is the same additional Deputy Commissioner who has given the land permit. The irony of it is this, Your Lordship. So he is asking the Deputy Commissioner Mon to keep his image before the public. Lordship, instead of protecting the privilege given to a certain distinguished person, if the administration allow encroachment by individuals or government, it does not show any good image before the public. So the direction now is, you are thereby asked to conduct special inquiry and submit report. What is the direction, Your Lordship? The direction is to keep his image and then, Your Lordship, to conduct special inquiry.
Okay.
Yes, Your Lordship. However,
no, but when WP 204 was decided,
yes,
what did the government say in that WP 204?
No.
Because the court has specifically stated that the claim of the writ petitioner has not been disputed.
Your Lordship, till date, we are not disputing that the land permit was not given to him. We are not disputing that, even up to date. Your Lordship will also find that in the committee report. We are not disputing. We are not disputing that the permit was not given to him. No. We admit that the permit was given to him. But we are saying that allotment was never given to him. Your Lordship. In our affidavit, Your Lordship, if you see, we are not saying that no, the permit was not granted to him. We are not saying that. We say we admit that the permit was given to him, but the permit was given to him for a particular purpose, that is for cultivation only. And this permit cannot be construed, Your Lordship, into something else. Then, Your Lordship, before going further into this read petition 204. I wanted to make one submission on this particular permit. Your Lordship, the law is settled as far as any deed is concerned. The language that has been used, the meaning that comes out from the deed itself, only that has to be taken into consideration. It cannot be construed in any other ways. I will place my citations on that, Your Lordship. What is happening in this present writ petition, my Lord? What is happening in the present writ petition is that the permit now is construed
to be an allotment.
Yes, to be an allotment. But the law is settled on that, Your Lordship. It has to be in the meaning and the words that is being used in the deed. That has to be taken into consideration, not in the meaning that I construed it or any other person construed it, Your Lordship. I'll place my citations on that, my Lord. Now, Your Lordship, after the Chief Secretary submitted this letter directing the Deputy Commissioner to conduct a special inquiry. See, my Lord, here, the only direction that was given by the then Chief Secretary to the Deputy Commissioner was to conduct a special inquiry. Nothing more. Besides, of course, the other things, which is to keep his image.
Submit report.
Yes, that's the only thing, Your Lordship. Now, since this has not done, the petitioner approached the Honorable Court as stated by my learned friend here,
Yes.
by filing this, the WPC 204K of 2012. Now, 204K of 2012, Your Lordship, was disposed of by a judgment order dated 5/8/2014. Your Lordship,
Yes.
I wanted to take my Lordship to para 5 because this is what my learned friend has referred to.
5, yes.
Your Lordship, the first two lines, allow me to read the first two lines and make my submission, Your Lordship. The first two lines says, the grievance of the petitioner in this case is simple. The land in question was gifted to his father on 29/3/1971. In the present writ petition, the petitioner is saying that this land is allotted to his father. Now, by the observation made in 204K, it appears that the petitioner has made a submission before the court that this land was gifted to his father. And therefore, the court has made an observation that the grievance of the petitioner in this case is simple. The land in question was gifted to his father. Now, Your Lordship, if it is a gift, will it not attract Transfer of Property Act? And if this is not gifted to his father, then, Your Lordship, this is just an observation of the court. This is not a direction. Para 5 is an observation of the court only, Your Lordship. The direction is at para 6. And if my learned friend, Your Lordship, is saying, and the competition is saying that para 5 is a direction, Your Lordship, then it squarely attracts the Transfer of Property Act, Your Lordship. And then we'll have to go and see whether in the Transfer of Property Act, what is a gift deed and how it has to be executed as far as the immovable property is concerned.
The court also said if there is any encroachment, definitely this is prejudicial to his legal and constitutional right.
Yes, so this is an observation. This is not a direction. Now, if this is a direction, then, Your Lordship, I'll have to make my submission on the gifted property as far as the immovable property is concerned.
Direction is in para 6.
Yes, direction is, this is an observation. Because, Your Lordship, the counsel for the petitioner was saying that this paragraph 5 is also a direction. And if that is so, Your Lordship, then we'll have to go and see the Transfer of Property Act, my Lord. Yes. However, to my understanding, Your Lordship, paragraph 6 is a direction. Paragraph 5 is an observation of the court. Now, what does paragraph 6 says, Your Lordship? Although an affidavit in opposition has been filed on behalf of the official respondents, the claim of the petitioner has not been disputed. The fact to the issuance, as to the issuance of direction by the Chief Secretary is also not disputed. We are not disputing all this, even today, Your Lordship. That being the position, I feel inclined to allow this writ petition and direct, see, Your Lordship, directions comes now. Direct the Deputy Commissioner Mont to hold special inquiry as was directed by the Chief Secretary by the order dated 18/7/1996, within a period of 3 months from the date of receipt of the certificate copy of this order without fail, and forward the same to the Secretary for passing necessary order. So, Your Lordship, the court is also now reiterating the direction given by the Chief Secretary, which is to hold a special inquiry committee, to constitute a special inquiry committee, and to submit this report. Nowhere, Your Lordship, by this order or by the letter submitted by the petitioner, does it prove or shows that this land is allotted to the petitioner's father or to the petitioner, for that matter, my Lord. Nowhere. The order of the court, Your Lordship, the order of the court and the letter of the Chief Secretary is reiterating each other that on one point, that is, conduct a special inquiry. Nothing more than that, Your Lordship.
Okay.
Now, Your Lordship, in compliance to this Honorable Court order, a special inquiry committee was constituted with ADC TG as its chairman. Your Lordship will find it at page 55.
Yes.
Background has been given. However, Your Lordship, since my learned friend has already read it, I will not take my Lordship there. I'll take it to page 50. I'll take my Lordship to page 56. The first para. The first para. As a background to the, I may be allowed to read this. As a background to the case, it is to be noted that the land for Tijit Township was donated by Jabaka village measuring 1,200 acres. The donation was made to the government by the village free of cost without any terms and conditions, which was agreed verbally. This farmland also falls within the area donated by the Jabaka village. Very clear. This, Your Lordship, as can be seen from the report, that this particular background, all this report was prepared after the spot verification was conducted.
Acha. So this Dizit township, the land belongs to the Japuka village.
Yes, part of the land also was donated by the Japuka village.
Not entirely.
Not entirely, part of the village. But this land, the land that falls, the petitioner is now claiming, is part of that land, or part of that 1,200 acres which was donated by the Japuka village. We are admitting to that fact.
So, and the petitioner is from which village?
I have to ascertain that.
No, what I
No.
mean is, did the petitioner's village also have land in that area, in that Dizit area?
That so many villages are there. So
Cannot be, Your Lordship, because if it belongs to his village, then he will inherit it from the
that's
yes.
right, that's
But
right.
this is the land where the
So
permit was.
it appears that you are from another village
Yes, I'm not from
which had
Japuka.
nothing to do with that Dizit area.
Correct.
No, they also are from that area only. but the village, specific village.
No. The fact that you were allotted, you were given a special permit means
Yes,
that you
yes,
did not have land actually.
No, that land, the permit was, special permit was not in respect of my land.
Only
It
for
was not-
cultivation.
yeah, for cultivation, and at the same time, now it is from the record only, it will speak. Whether it is an allotment, permit, whatever it is, the record is very clear. Your Lordship. I am
No,
only
permit
speaking
and
on the
allotment
basis-
is different.
It's different.
Yes, permit and allotment are different, Your Lordship. But the record, subsequent records, records, they speak to the fact
We'll see,
that,
okay.
yes.
We'll see.
And it is not
Yes,
my record. That is my
let
only
him-
case.
let
That is
him
my only, I am
complete.
not, I going into all these minor technicalities, they are not of importance to me. Your Lordship. They are not of importance to me, and it is not important to the present case. It is not at all. Because the record, what does the government say? What does the court say? Those are the only thing I know.
No. The
May I
question
continue,
as to
madam?
whether allotment is allotment or permit is very important because
Your
as of
Lordship,
now,
yes.
as of now, the entire area is now populated, and already so many buildings, so many individuals are now residing there. So it has become very, very important that this should be
Yes.
decided. Yes.
It should be, but then this honorable court at that point of time in 2004, it was it was the government's case to, if at all, fight. That it is not, it is just a mere permit, it has no right. They did not say. They say that all the statements are admitted.
No, they did not object to the inquiry.
Yes, they did not object. And
It was just for the inquiry.
It is just for the inquiry,
At
Your
the same
Lordship.
time, the chief secretary himself who allotted the land. At that point of time in the 70s, the chief
No,
secretary.
no allotment, Your Lordship. No allotment was done.
Whatever it is.
We have
Your
to
Lordship,
see.
I am not going into whether it is a grant or whatever, permit, whatever, at that point
No,
of time
no,
when
no.
it was given to
That
my
is the crux of the matter.
That is the crux of the
That is
case.
the crux
Correct.
now.
Ah.
But
That is the crux of the case.
But the judgment is it encapsulates the scope.
No, judgment is only for inquiry.
And
Judgment
in the
is only
judgment
for
also, paragraph 5, that is the observation of the court.
Observation,
Based on which
observation.
the court has, had the court not observed that thing, come to that conclusion.
No,
on
see,
the-
observation, we also make many observations. What observations means from the writ petition also we draw the observations.
Correct. Yes.
So whatever was stated in the writ petition, the court has drawn from the writ petition and has replicated it in para 5.
No, it should be on the basis of the.
On the-
basis
on-
of the
on the
letter
basis of the writ petition.
No, not on the, purely on that. Your Lordship will see here the.
On the basis of your submissions and the writ petition,
And the-
I
and
mean
the
the
report.
counsel for the petitioner and the writ
The record,
petition.
Your Lordship, because.
That has been,
he-
anyway, we
yes,
will.
he
yes.
reflects the record, Your Lordship. It is not my submission. may have
Because
to-
the petitioner may have stated
Yes.
that it was gifted. May have stated in the writ petition that it was gifted. That's why the court also said it was a gift.
No,
Yes.
the chief
Yes.
secretary has said specifically that it was given. The chief secretary has clearly said that it is given. The court has based on that, not on the submission of the petitioner. It is on the basis
Anyway,
of
anyway.
on the
Yes,
chief
yes.
secretary's
Yes,
order.
yes, please continue.
Okay, Your Lordship. So now, Your Lordship, from this report, another thing that comes out, Your Lordship, is that the land which the petitioner is claiming to be the owner is actually a land which has been donated by the Japoka village to the respondent number 5 in the present writ petition to the government.
Part of 1,200 acres.
Yes. Now, Your Lordship, on account of the land donated by the Japoka village to the government, the government becomes the owner of that plot of land. That cannot be disputed. And because I am the owner of the land, Your Lordship, that is the state government, is the owner of the land, I permitted him to cultivate those plot of land. Now, until and unless I allot that plot of land to any individuals, the land still holds as on date that it is mine. That is the state government. Until unless I alienate it by way of allotment. The state government have never done that, Your Lordship. And by the very issuance of the permit, Your Lordship, by the very issuance of the special permit,
Acha, when was this 1,200 acres given?
Way back, Your
By
Lordship.
the Jabuka village? 60s?
Yes, Your Lordship.
Later says, Your Lordship, I have taken your Lordship to the particular letter.
No.
1981, the letter of the in my petition, Your Lordship, there is one annexure which talks about the
No, Your Lordship may kindly refer my affidavit in opposition at page 24. This is there.
I'll show Your Lordship the record only. I am not going to make submissions beyond what is on the record.
Page 24. This is a letter written by the Jabaga Village Council that Para 2, Your Lordship. The Jabaga village has offered donated free of cost for land measuring 1,200 acres for TG town development to the government of the Nagaland for the well-being of all.
No, but when it
So
was
TG
given?
town development, Your Lordship, took place in 1960s.
Page 37, Your Lordship. This is
And they are represented here, Your Lordship, the Jabaga village.
18 July 2008 and 1981.
Lordship, if Lordship may kindly see the affidavit
1 minute, okay.
for respondent number 5, annexures, though no specific year has been mentioned, but in 1978.
No, page 37 also doesn't indicate any year.
Yes,
But
Lordship.
then there is one page 8. There is a copy of agreement in connection with boundaries of 13 June 1978. There is one agreement here they have given, Your Lordship. Agreement in his affidavit, the private respondent number 5.
Page 7.
Yes. Page 8, there is an agreement.
Type copies at page 8, Lordship.
1978. So it was
Lordship,
after the.
no, Lordship. Lordship, may kindly see the language.
78.
As agreed earlier. So the land was already given before. Prior to 1971, before the special permit was given. The land we have given already. But just to make it official, Lordship, this document was made. There is no dispute that I have donated the land to the government, Lordship.
No, there is no dispute. But the court wants to know the exact year when it was given.
As and when the
Because
proposal was
that is
signed.
also vital.
Yes. I can ascertain that fact.
Yes, then?
Yes, now, Your Lordship.
So you said that since government is the owner, government has given the permit, but government has never given him allotment.
Correct, correct, my lord. Correct, Your Lordship. Now the committee findings, Your Lordship. The first para. Committee findings, Your Lordship, at page 57.
Page 57.
57.
Yes.
The first para. The special permit issued in 1971 via memo number such and such dated 29th of March 1971 issued by the then ADC Mon is authentic. However, there is no record of payment of revenue to the government and the permit does not stipulate any terms and conditions governing the special permit. Here also, Your Lordship, from this para also it clearly indicates that the allotment has not been done because if pata has been issued, then Your Lordship, tax has to be paid. Revenue has to be paid, Your Lordship. Here also it's very clear. And again, Your Lordship, I'm reiterating this. We are not disputing to the fact that the special permit was given. This committee also is not disputing that. And we are not disputing that even in our affidavit in opposition, Your Lordship. Now, Your Lordship, again at para 2, it is an accepted fact that the land of Tijit headquarters town. See, Your Lordship, here also Your Lordship will find as to when that land has been donated. It is an accepted fact that the land for Tijit headquarters town was donated by Jaboka village to the government and the special permit itself was issued to late L. Wanshu by the government in view of the rapidly growing population of Tijit town The district administration need more land for development of the town to appease the growing needs of land for dwelling units. The district administration have issued permit for the purpose of expansion and development of the town. Your Lordship. Now, 3. There are already 111 numbers of permit issued by the district administration from 1988 till date. Further, 12 notes of plot were settled through the complainant and 17 notes without any permission, adding to 140 members already settled in the area. Trying to relocate these 140 odd families will create a lot of social tension, leading to a grievous law and order problem in the town. The committee, Your Lordship, the views now of the view that to bring an amicable, immediate and amicable settlement to this issue, an alternative arrangement may be offered to Sri Wanshu Konyak by offering him 200 to 300 square feet of land presently occupied by him, and also in recognition of the service rendered by his father late L. Wanshu, either a school or a public hall in the locality be named after him. So this was the views given, Your Lordship. The committee has given its views. Your Lordship, the petitioner did not accept this particular committee report. And therefore, to come to an amicable settlement.
Yes.
To come to an amicable settlement, Your Lordship, the district administration had a series of meetings with the petitioner, which Your Lordship will find the meeting minutes at page 67.
Page 60.
67, my lord.
Yes.
These are the meeting minutes, Your Lordship, held with the petitioner. I may be allowed to read this, my lord.
Yes.
A report of the meeting held with Sri Nogman Wanshu, son of late L. Wanshu, in connection with special land permit dispute relating to WPC 204K of 2012, Sri I. Nogman versus State of Nagaland. The subdivision administration, as directed by the DC Mont, held a meeting with Sri Nogman Wanshu on 10th of 7, 2015, and also on 31/7, 2015, in the office chamber of the Additional Deputy Commissioner Tijit, with a view to sort out the outstanding issues regarding the allotment of land. Your Lordship, the next line is important. During the meeting, certain contention points, demands, and proposals submitted by Sri Nogman was discussed primarily. Point by point discussions are given here. So, Your Lordship, to settle, the petitioner has put a demand. We had a meeting with him, and the demand was discussed. These are the demands that he has placed, Your Lordship. 1, resurvey of the special permit as per 1971, but not as per 1975. I may be allowed just to read the first paragraph because this is relevant, my lord. Resurvey of the special permit has already been carried out on 27/10/2014 with the help of a retired Dubashi, Sri Achok and Sri Zenai Konyak, caretaker of Sri Nogman, as these two individuals were present on the spot physically during 1975 resurvey of the 1971 special permit. The areas as per resurvey done on 27/10/2014 with GPS measures 157.81 acres. Now this is the total area, Your Lordship, of the special permit that was given. This is not disputed. Now, Your Lordship. Demand number 2. Release of compensation from all household or this settled via permit issued by the administration within the jurisdiction. This is the second demand. In the course of development of Tijit town, the need to cater to ever-increasing populations necessitated the administration to issue permit to meet the expansion of the town during various stages and of officers at Tijit. On verification, it has been found that the district administration has issued 111 notes of permit from 1988 till date. It is also found that the complainant, also in his own capacity, has been selling a allotting plot of land to private individuals without the consent and approval of the government. In this connection, the district administration have received representation from TG Town Public Union, the Jaboka Village Councils, actual landowners seeking clarifications and complaint against allotment of huge acres of land to a single individual, as it is threat to their existence and development activities to the TG Town in the near future. As such, conceding to this demand will create law and order problem in TG Town. So the same issue of compensation, Your Lordship, was sought for. And I will show you how it is unreasonable on the part of the petitioner to even seek compensation, Your Lordship. Why it was declined, and it is how unreasonable it is on the part of the petitioner to come to this honorable court and seek compensation, Your Lordship. I will satisfy my Lord on that. 3. Restorations of all vacant plot areas to me falling within the special permit. The subdivision administration offered to allot all land, all vacant plots that exist within the survey area down on 27/10/2014 to the complainant if he agrees to relinquish his claim over the site allotted by the administration. The complainant did not agree to the offer made by the office. Here, Your Lordship, taking a pause, I wanted to submit something here, Your Lordship. It says the subdivision administration offers to allot all vacant plot. If allotment has been done by the 1971 special permit, why should re-allotment be done? Why should re-allotment be done, Your Lordship? And if allotment is there on the basis of that special permit, why should the administration discuss this point by saying that we'll allot you the vacant plot? This also indicates, Your Lordship, that there was no allotment made. And Your Lordship, the petitioner did not contest it in the meeting setting that why should allotment be given to me when I have already been allotted with this portion of land?
No, he did not agree to the offer.
Yeah, he did not agree to the offer.
The complainant did not agree to the offer.
Yes. He did not agree to, no, Your Lordship, he did not agree to the offer that he should relinquish his claim over the site allotted by the administration. That offer was given to him to allot the vacant plot.
The remaining?
Yeah, the remaining, yes. 4, Your Lordship. The petitioner is saying that by taking all my plot of land, they are renaming one school in my name. This is his demand, to recognize the said area of land as El Manshu colony in memory of my late father. These are his demand.
So that was agreed.
That was agreed. This is not something that this is not something that the land has been taken over by the government and then we are re-allotting as stated by the petitioner. No, these are his demand. And the administration agreed in principle to forward for recognition and renaming of the present industrial colony to El Wanshu colony as and when the differences are settled. See, my lord. And then to stop all issue of fresh permit without my prior consent, my consent prior to 1971 special permit, and to stop all this, we have, the administration has agreed to whatever the petitioner is stating. I think, Your Lordship, it's...
Ah, yes.
Yes.
Let's continue.
YANNU.
1 minute, 1968. And petitioner's village is
Yanu, Y-A-N-N-U.
Y-A-N-N-U.
Double N-U. Yanu village, yes.
Okay.
That's the information I just received from
Okay.
my.
Page 29 is the report. Page 29. A lot the donation by all the villages, huh? Not by the Chakoka. Page 16, page 29 of the petition. Huh? But it is not only Chakoka. All the villages, yeah.
But my village.
Yeah.
Yes,
Yes, my lord.
we were
On
this,
page 67.
Yes.
Now, your lordship, as submitted, the petitioner has put certain demands which was discussed on a meeting held twice. Some of the agendas or the demands that has been put by the petitioner was agreed, some disagreed. However, no conclusions could be
Yes.
could have been achieved, your lordship. Thereafter, my lord, by an order dated 24th of September 2018, which your lordship will find at page 80 of the writ petition. This is order dated 24th of September 2018. By this order, your lordship, the special permit that was granted to the petitioner was cancelled with immediate effect. Yes. I may be allowed to read this, your lordship.
Yes. Please read.
Your lordship. Government of Nagaland, Office of the Deputy Commissioner, Mount Nagaland, order dated 24th September 2018. In pursuance to the letter from the Home Department, Government of Nagaland, vide letter number such and such dated 14th of September 2017, with regards to the special inquiry report on the special permit issued to late Wanshu Konyak for farmland at Tijit headquarters. The permit number such and such dated 29/3/1971 is hereby cancelled with immediate effect in view of the expansions and development of Tijit administrative headquarters, requiring all vacant land for public office establishment. Now, this was done in pursuance to a letter dated 14th of September 2017. I want my lord to mark this date. I'll be coming back to this again, your lordship.
Letter from the Home Department.
Yes. Dated 14th of September 2017, your lordship.
14/9/2017. Yes.
Now, your lordship, after cancellation of this order, what happened was that, your lordship, the petitioner has again submitted a representation dated 5/3/2019. Your lordship will find that at page 78 of the writ, annexure O. I'll only refer the relevant para, your lordship.
This was written on
5/3/2019.
Okay. Annexure.
These are the, yes.
Dated
5/3/2019.
2019. Yes.
Only the relevant para, your lordship. It is written to the chief secretary. Subject is prayer for settlement of land dispute with regards to special permit 29/3/1971. And the last para, your lordship. The facts he has narrated, your lordship, we don't need to go into all this again. The last para, therefore, it starts with therefore. Therefore, in view of the above facts and circumstances, the undersigned hereby humbly appeals to your august authority to kindly settle the case once and for all in the interest and for the end of justice. So he has again approached the respondent authorities to settle the case. This was given after the cancellation order was issued, your lordship. However, taking into consideration the representation submitted by the petitioner, your lordship, another resurvey was conducted. And we have submitted that report. Your lordship will find it in our affidavit, filed in WPC 58 of 2017.
Affidavit in a position
Yes.
on behalf of respondent 1.
Yes, my lord. Here, my lord, at page 24,
In view of the petitioner's representation,
Yes,
dated 5-3.
we again conducted a review. A resurvey was conducted again, Your Lordship, in order to settle the case once and for all. And the report of this particular review survey was submitted to the Deputy Commissioner on 1st of February 2020.
Yes. Let's see.
Yes, sir. Sir, in reference to the Home Department letter number such and such dated 27th of January 2020 and as directed by the authority, survey was conducted on 31st of January 2020 with the assistance of surveyor, Department of Land Records and Survey, MONT, and DB of Digit. Detailed survey report with respect to the land under special permit as sought by the Home Department is provided as per the format requested.
Which annexure is that?
Page 24.
Annexure 8.
Annexure 8, Your Lordship. I am reading the reference part.
24. Annexure 8, yes.
Your Lordship. Now, total area as per the survey is 157.81 acres. This is why, Your Lordship, I was mentioning that 157.81 acres. This is important. Now, this is the area, and we are not disputing to this area. We are not disputing to this at all, Your Lordship. So total area as per the survey is 157.81. Number 2, allotted to government department offices by the office of the ADC Digit is 0.9280 acres. 3, allotted to private individuals organization by the office of the ADC Digit is 38.0014 acres. 4, allotted to private individuals organizations by the office of ADC Digit and the plot are presently vacant with no construction carried on it, 4.43 acres. 5, may I proceed, my lord?
Yes, yes.
5,
sold
or given to the private individuals organization by Sri L. Nogman Konyak and permit obtained from the same from the office of the ADC Digit is 76.912 acres. Sold or given to private individuals organization by Sri L. Nogman Konyak and no permit obtained from the office of the ADC Digit, 17.548 acres. Sri L. Nogman Wanshu residence and his fishery pond measuring 0.67 acres is also within this area. 7, sold or given to private individuals by Sri L. Nogman Konyak and permit taken but the plots are presently vacant with no construction carried on it, nil. Next page, my lord. Sold or given to private individuals by Sri L. Nogman Konyak and no permit taken and the plots are presently vacant with no construction carried on it, 0.2295 acres. Plot occupied by private individuals, organizations not sold, given by Sri L. Nogman Konyak and permit also not obtained by the office of the ADC Digit, 0.05171 acres. Vacant plots and not sold and given by Sri L. Nogman Konyak and no permit given by the ADC office, 7.674 acres. Circular road and drainage. Your Lordship, see, the next para is important. The total area claimed by L. Nogman Wanshu to arrive at out of court settlement is 5.1 acres, out of which 4.43 acres is presently vacant with no construction and 12 permits are issued by the office of the ADC Digit and the remaining 0.67 acres is his residence and fishery pond. So this survey was conducted as per the representation submitted to settle the matter out of the court by the petitioner. Your Lordship, the survey report. Now, Your Lordship, the next page. See again the background. I'll read only the relevant para, Your Lordship. The first para. On 13/11/1968, an agreement was entered between the district administration, regional council members, and various villages to change the nomenclature of Japoka Circle Headquarters to Digit Circle Headquarters, and also shift the locations of the Circle Headquarters to the present township, Digit Headquarters. Agreement papers enclosed. In the said agreement, it was also agreed upon the portion that the land required for the establishment of Tijit Circle headquarters will be given by the villagers without any objection. On 16th of November 1969, the then Commissioner Nagaland Sri such and such has inaugurated the present headquarters. Your Lordship, para 3, starting with initially. Initially, the area was thick forest, where human habitation was not expected in view of the land conditions. The then ADC might have issued a special permit for farming only, so that the jungles can be cleared for human settlement. Likewise, late L. Wanshu has cleared the jungles and developed the land by way of banana plantation and sugarcane plantations. Again clear, Your Lordship. Why permit was given? Again clear. In the year 1975, the next para, my lord. In the year 1975, there was an encroachment upon the farmland by Sri Nokzem Konyak, Chief Ang of Jaboka and Land Tingnong DB. The then CO circled officer Sri such and such has stopped the encroachment since L. Wanshu was developing the land by cultivating sugarcane, banana, etc. As years progressed, many government department was established in Tijit headquarters, which led to urbanization, as a result of which villagers migrated from neighboring village to the present headquarters. Due to rapid urbanizations, Sri L. Nogman Wanshu, eldest son of L. Wanshu, late L. Wanshu Konyak, started to sell out acres of land by virtue of special permit issued to his father to individuals without knowledge or permissions from the government. At the same time, due to increasing needs of public utility services, the office of the ADC Tijit has also issued permit to government department and individuals within which the boundaries of the special permit issued to late Wanshu in 1971. Being aggrieved, Sri L. Wanshu made a representation before the Chief Secretary, Nagaland, who issued a direction to DC Mond by order dated 18/7/1996 to hold special inquiry and submit report at the earliest. The special report did not materialize for 18 years' time. However, on 12/9/2014, a special inquiry committee was constituted by DC Mond to verify the case. The special inquiry committee has successfully conducted a verification and placed its report to the government. During the conduct of the inquiry, various complaints against Sri L. Nogman was received by this office. Now, Your Lordship, the present status. This is very important, Your Lordship. See, the present status. On 27th of January 2020, the Home Department directed the office of the ADC Tijit to submit details of the land wide letter number such and such. Accordingly, survey was conducted and the following are the details. 1. Total area as per the survey, 157.81 acres. Area allotted by the office of the ADC Tijit, 38.0014 acres. Areas of land sold gifted by Sri L. Nogman, 76.912 acres. So this much area of land, without having the allotment, he has sold it. Now, Your Lordship, before I go to the next page, I want my Lordship to come back to this writ petition 88. To the writ petition 88, Your Lordship,
Yes.
at page 81. Now, this is impugned, Your Lordship. This is impugned. Allow me to read this, Your Lordship, the relevant para only. To the Deputy Commissioner Mon, subject regarding special permit for farmland at Tijit, dated 23/9/1971 to late Sri Wanshu Konyak. Sir, please refer to the subject cited above and the letter number such and such dated 1st of February 2020 from ADC Tijit addressed to you with regards to the status of the entire land under the special permit existed on date and another letter, such and such, dated 8th of January 2020 from the ADC Tijit addressed to you, mentioning the meetings with Sri L. Wangshu Konyak for settlement of the entire dispute concerning the aforesaid land. And what does it say, Your Lordship? It says, number 2, the detailed report of ADC Tijit of the land under special report shows that out of 157.81 acres of land, initially, Sri L. Nogman has over the decades sold given 94.0195 acres of land to various individuals, organizations, which is about 60% of the total land. Your Lordship, see, 60% of the total land. The area of the land which is allotted to private individuals, organizations by the office of ADC Tijit is 42.4314 acres. The land utilized for the government department offices and for roads and other public utilities like drain is just 16.92 acres. The report also mentioned that after resurvey, the land alone under actual possession of Sri L. Wangshu Konyak, his residence and fishery pond is 0.67 acres and not 5.1 acres as reported earlier. The report says that the vacant land behind the house of Sri L. Nogman Wangshu Konyak, which was allotted to 12 private individuals by ADC Tijit in 2012, and which has been asked now by Sri L. Nogman Wangshu for resettlement, covers an area of 4.43 acres. So the entire area, Your Lordship, is stated here. At the end, para 5 is what the government is giving the decision. Para 5. I may be allowed to read this para 5. May I read, my lord?
Yes, yes.
Further, in public interest and taken into account in present circumstances as exist in Tijit town, all the vacant plot tracts of land falling under the special permit need to be kept for use by any government office or for taking up any developmental activities that may have come up in future. Hence, you may take immediate steps for cancelling the allotment covering an area of 4.43 acres to 12 private individuals made by ADC Tijit in the year 2012, which is consolidated tracts of land at one place and mentioned as serial number 4 in the report of ADC Tijit dated 1 of February 2020 and taken under the custody of the government. So the government have decided to cancel the 12th allotment of land, which has already been done. Para 6.
That's not true.
Yes, the 12 individuals allotment which has been given and where the decision has been taken to cancel it, the allotment has already been cancelled, Your Lordship. Para 6.
Is that the one which is impugned? The cancellation? Cancellation?
Yes,
12
yes,
individuals?
correct, my lord. 6. The vacant plots and not sold given to private individuals by Sri L. Nogman Wangshu Konyak or allotted through any permit by ADC, as well as those plots sold given to private individuals by Sri L. Nogman Konyak Wangshu but vacant, mentioned as serial number 10 and 8 in the report of ADC, which measures 7.674 acres plus 2295 acres, totaling to 7.9035 acres, may also be taken over by the government. In all these cases, proper allotment orders in a manner as considered appropriate by you may be made, so that there is absolute clarity that these tracts of land belongs to the government. Number 7, this is important again, Your Lordship. As regards the land already allotted to private individuals by Sri L. Nogman Wangshu and which are not vacant, with some construction or some development of the land done in some manner, and for which permits have already been given by ADC Tijit as mentioned in serial number 6 of the detailed report from ADC Tijit, you may prepare a proposal and submit to this office for regularization such allotment by getting permit issued by ADC Tijit. Action on similar line may also be taken for an area of land 0.517 acres, which is not vacant, and over the years have got occupied by private individuals, organizations without being allotted by ADC Tijit or been sold or given by Sri L. Wangshu Konyak as mentioned as serial number 9 of the report. Your Lordship. So all in all, what I'm trying to show is this, Your Lordship. All in all, this report this particular letter is issued in pursuant to a report. And that report is mentioned over and over again in this letter, which clearly shows that, Your Lordship, this is a subsequent order passed in pursuant to an original order. And what is that original order, Your Lordship? That original order, Your Lordship, is the order dated 1st of February 2020, which is at page 24. Which is at page, no, page 24 of my affidavit in opposition, which I've read it.
Yes, that one which you have read.
Yes. Now, Your Lordship, these documents were there before the petitioner. As I filed this, and it was there before the petitioner. And it is on the basis of this particular survey report. This letter, which is impugned in the present writ petition, has come up. The petitioner is not challenging this particular order dated 1st of February 2020. But in other words, the petitioner is not challenging the main order, but the petitioner is challenging only the subsequent order, Your Lordship. That brings us back to the same question which I've raised in the other two writ petitions. Is the petition maintainable? No. No. I would also like to take my Lordship to the order, that is page 80. Page 80. This is also impugned, Your Lordship. Order dated 24th of September 2018.
This is also impugned.
This is also impugned. And the letter, that's why I have said this dated 14th September 2017 is important. This is also, Your Lordship, this also is born out of the order dated 14th of September 2017 issued by the Home Department, which Your Lordship will find it at page 22 of my affidavit in opposition. Filed in WPC 58 of K of 2017 at page 22. I have an exit.
This 14 September 2017.
Yes. What was the direction given there, Your Lordship? Allow me to read this. Direction 1. There are two directions given.
1 minute, okay. 14/9/2017.
There are two directions given, Your Lordship, here. Direction number 1, the special permit issued via number such and such, dated 29/3/1971 to late L. Wanshu Konyak for farmland at Tijit may be cancelled with immediate effect in view of the expansion and development of Tijit administrative headquarters, requiring all vacant land for public office establishment. So in compliance to this direction, this order, which is impugned, has come up. But the petitioner has not challenged again this particular letter dated 14th of September 2017, my Lord. Most importantly, Your Lordship, by the same letter, another direction was given. Number 2, I may be allowed to read this again, my Lord.
Yes.
It says, regarding physical occupation, see, my Lord, physical occupation by way of permanent structures by Sri Nogman Konyak, son of late Sri Wanshu Konyak, physical verification may be made by DC Mon, after which proper land allotment for permanent possession of the land may be made. Here, the issue of allotment arises now, Your Lordship. And the government now says that physical occupation,
he may be allotted.
He may be allotted, Your Lordship. And it was allotted, Your Lordship. It was allotted. Page 28 of the same affidavit. Your Lordship, as per the report, Your Lordship have already seen, the physical occupation of the petitioner is 0.67 acres. Now, what does this order say, Your Lordship? I may be allowed to read this.
Yes.
Order dated 25th of February 2020, with reference to the Home Department letter dated 25th of February 2020, Kohima, in respect of special permit for farmland at Tijit, dated 29 March 1971, to lay Sri Wanshu Konyak, a plot of land measuring 0.67 acres, bounded by the schedules of boundary as mentioned below. North, MK John Fishery Pond; east, government land; west, approach road; south, Shipa Konyak, is hereby allotted to Sri L. Wanshu Konyak, Nogman Wanshu Konyak. So allotment has been given, Your Lordship. Now, this particular allotment order is also not under challenge. Now, Your Lordship, as with regards to the allotment of the land now is concerned, I agree with the petitioner. Allotment was given. Allotment was given by an order dated 25th of February 2020. Allotment was given only for 0.67 acres, not 157.81 acres. So I agree, Your Lordship, allotment is there. Allotment is there only for 0.67 acres. Now here, Your Lord, my Lord, if in this 0.67 acres that has been allotted to the petitioner, if the government give another reallotment to any private individuals or to any office establishment, the petitioner has got every right to come and say, like, give me compensation. In these 0.67 acres, the right of the petitioner to claim compensation or ownership of the land exists only in these 0.67 acres, not in the area of 157.81 acres, my Lord. And therefore, Your Lordship, I wanted to raise a very important issue, Your Lordship. The very important questions I wanted to raise before this Honorable Court is this, Your Lordship. Can a person or can an individual, without having titleship, without having the titleship over a land, claim ownership, Your Lordship? How do I say this is my land, my Lord? How do I say that? I have to have the titleship over the land, my Lord. And titleship are given to me in the form of Jamamandi, in the form of allotment orders. Without the titleship, can anybody say that I own the land? Or can any individuals claim ownership, Your Lordship, without titleship? Your Lordship knows better than me. The answer is plain and simple, no. A person can claim ownership only on the basis of the title that he has, Your Lordship. And this titleship, we have never given it to the petitioner or to his father. And in our affidavit in opposition, we have stated that numerous times, stating that the land has never been allotted to the petitioners, neither to his father. Your Lordship, the petitioner has not replied to the affidavit that we have filed. What does the law say, Your Lordship? Here, the very crux of the case is, Your Lordship, who holds the titleship? That is the crux of the case. And we have in our affidavit of opposition stated in as much as 3 and 4 paras that the land has never been allotted to the petitioner's father, neither to him. The petitioner has never filed an affidavit denying such contentions made. The law is settled, Your Lordship. If you do not deny the averments or the contentions made, by the other parties, it is deemed to have been admitted. I can give you the paras, Your Lordship, where we have mentioned.
No, if they have not filed any reply to this affidavit, you're talking about the affidavit filed in WP 58.
Yes, so also in 88. So also in 88, Your Lordship. They have not filed. And in para 14, 15, 16, we have mentioned all this. Having said that, my lord, having said that, Your Lordship, any order which is subsequent in nature, without challenging the main order, can a petition survive?
Yes.
Can the petition survive, Your Lordship? Without having a titleship, without having a title,
Okay. So is the petitioner's name also there in that agreement, that page 30 agreement, where some ANGs, GPs and members of Digit Circle stated that they
No, it
they're-
was, no.
no.
Because they were RCMs, through their intervention, they were doing all the background works, and then finally, through their endeavors, all this,
No,
villages,
so-
these are only ANGs, and
No. What I mean is when they say that necessary land required for the headquarter will be
Yes.
given without objection, and certain villages have been named. So which means that Digit headquarter land
Yes.
is given by these villages only.
yes.
And petitioner is from Yanu village, which is not included.
Yes.
Okay. Yes. Then
Now, Your Lordship, I wanted to take my Lordship to the prayer portion of this writ petition 88. 88 of 2022.
yes.
Your Lordship will find the prayer portion at page 26. There are two specific prayers made, Your Lordship. One, quash and set aside the impugned special inquiry report dated 31/10/2014. The impugned order, as far as the inquiry report, Your Lordship, that I leave it to my Lord. Your Lordship, the impugned order dated 24/9/2018 and the impugned letter dated 25/1/2020. The impugned order 24/9/2018 and the impugned letter 25/1/2019, I have already explained, Your Lordship. These are the consequential orders. The petitioner have not challenged the main order, therefore it is not maintainable. Coming back to the second prayer, Your Lordship. Direct the state respondent to pay land compensation to the petitioner for the area of land covered by 1 numbers of permit issued to the settlers on the petitioner's land, and further direct the state respondent not to encroach any further and desist from issuing any more allotment permits against the land encompassed by the special permit. Now, Your Lordship, what is this prayer? Prayer 2. Asking this court to direct the respondent to pay land compensation. Is it not asking this court to declare the titleship?
Only if the court decides
Yes.
that the petitioner is the landowner.
Yes.
Then only.
Yes. Then, Your Lordship, here, I have certain reservation. And that reservation is based on the decision given by the Honorable Apex Court, wherein it says that the writ court cannot
Decide the
cannot decide the titleship as far as the titleship is concerned. And to give compensation to the petitioner means that it is this honorable court is declaring the titleship. I'll place my citations on that, Your Lordship. Now, if these two prayers of the petitioner, if it is not maintainable, then, Your Lordship, what more is there is left for this honorable court to do besides dismissing the entire writ petition altogether, my lord? Now, to place my citation, Your Lordship, as stated by me, the deed, any deed that has been executed, cannot be interpreted I'd like to place myself 2024-7 SSC 245. Para 21, my lord. Para 21, my lord. Para 21. Allow me to read, my lord.
Yes.
It is a well-settled principle of interpretation that in an interpretation of a deed, the question is not what the parties to the deed may have intended to do by entering into that deed, but what is the meaning of the word used in the deed. The court can understand the true intent of the deed only by the words used in a deed. It does not matter what the parties in their most state of mind thought what the term meant. They may have different things, but still the terms or the language used in the deed should bind them. It is for the court to interpret such terms or language used in the deed. Para 22, my lord. In Ram Gopal versus Nandlal, it is held that in construing a document, the fundamental rule is to ascertain the intention from the words of the deed. See, my lord. The surrounding circumstances are to be considered, but that is only for the purpose of finding out the meaning of the words which has been actually employed in a deed. It would be opposite to refer the following para. Your Lordship.
This is regarding the permit.
Yeah, this is regarding the deed. That is the interpretation of the deed.
Yes.
Now, Your Lordship, with regards to, as I've made submissions with regards to averments, not contending the averments, Your Lordship. 2012-7 SSC 389, my lord.
(2012) 7 SEC
389. I'm referring to para 17, my lord. Para 17, my lord.
Yes.
May I read it, my lord? It is a settled principle of law of pleadings that an averment made by the appellant is expected to be specifically denied by the replying party. If there is no specific denial, then such averment is deemed to have been admitted by the respondent. In the present case, it is evident that the above noted averments in the writ petition was relevant and material to the case. In fact, the entire case of the appellant hinged on these three paragraphs of the writ petition. It was thus expected of the respondent to reply to these averments specifically. In fact, to make a proper reference to the records relevant to this paragraph, in view of the omission on the part of the respondent to refer to only relevant records and failure to specifically deny the averments made by the appellant, we are of the considered view that the appellant has been able to make out a case for interference. So they must specifically deny it, Lordship. Now, Your Lordship, with regards to the title sheet, whether this court has the power, I'll be referring to 2005-13 SSC 712, my Lord. Para 23. Para 23, my Lord. May I read it, my Lord?
Yes.
We, however, do not appreciate the approach of the learned single judge while passing his judgment dated 12/10/2002. He did not consider the question as to whether validity or otherwise of the notification 79/1949 issued under Regulation 6 of the Hyderabad Administration of Evacuee Property Regulation could have been cushioned in a collateral proceedings. He further did not consider the fact that the question of title cannot be determined in the writ proceedings, nor the identity of a person could conclusively be found out therein. The learned single judge furthermore did not advert to the limited scope of judicial review, namely that an administrative order passed by the state can be cushioned only on limited grounds, and while entering a writ petition, this writ court does not act as an appellate authority.
That is settled law.
Yes.
Writ court cannot.
Yes. Now, Your Lordship, before I conclude my submission, Your Lordship, I have got only 2-3 grounds, Your Lordship. First, the special permit, Your Lordship, is not an allotment in any circumstances. Number one, Your Lordship.
Yes.
It is not an allotment. Allotment, if any, Your Lordship, to the petitioner is just in respect of that 0.67 acres, which we admit, Your Lordship.
Made in 2020.
Yes, made in 2020. Thirdly, Your Lordship, nowhere in the writ petition, in this entire writ petition, nowhere the petitioner could have been able to prove his case, showing by way of a document that the land has been allotted to his father or to him. Meaning thereby, Your Lordship, the titleship is still with the state government. Yes, Your Lordship, we are not denying to the fact that the respondent number 5 has given the land to the government for the development of the TG headquarters. We are not denying that fact. So the landowners earlier was the petitioners, the respondent number 5. Now, on one of the land being donated to the state government, the land is now with the state government. The petitioner cannot, in any circumstances, say that by virtue of this special permit, he has been allotted the land, Your Lordship. The petition deserves to be dismissed, my Lord.
You have nothing much to say.
Nothing much. My learned friend has spoken everything
Yes.
that was in my mind also.
Except
Forget about what's in my document, but even my mind also he has already submitted. But Lordship, here I intervened, Lordship. I was not a major party.
okay, in this petition.
Even in the 204, writ petition 204, that was filed before, we were not made a party. That fact has been concealed, Lordship. Now, Lordship, going by the document of the government, they are admitting the fact that we are the owner of the land, the Japoga village, who has donated 1,200 acres. And that's where the petitioner is claiming his right. Now, Lordship, I've already pointed out, he's not from our village, Lordship. So at one point of time, we objected to his cultivation. But on the order of the government, Lordship, we have stopped intervening, Lordship. Now, the issue has been raised, who are the respondent number 5? Now, Lordship, the matter is very clear. The government is admitting the fact that we are the landowners. We donated. Now, Lordship, I'll just make one submission on the permit.
That's why I wanted to know when it was given.
In
You're saying it's
1968, yes. But it was reaffirmed way after 1975. Lordship, which I have already annexed in my affidavit. 78 and 2000. 1978 and 1980. We have reaffirmed. Lordship, the language used. Lordship, may kindly come to page 8 of the agreement. Page 8 of my affidavit, Lordship. As agreed earlier, because we have, in 68 we have given, but proper documentation was done in 1978, Lordship. So that is not disputed, Lordship. Now, Lordship, coming to the permit. Even assuming, but not admitting the fact that a permit has been given, Lordship. A permit has been given to the petitioner's late father.
Yes.
A permit has been given to the late petitioner's father. Whether the permit is transferable, Lordship. Whether a permit can be inherited. Land allotted, pata is given, that pata can be inherited.
Mutated, huh?
But permit, no. The permit is given to a particular person for a particular purpose, and the permit is over once the person dies, Lordship. Lordship, the language used. I'll just go to the first paragraph. I will not say much on this. Permit is not transferable. Page 32, Lordship, it's a part of the record. I'll just read it out, Lordship. Page 32. The permit, yes, in the petition, the permit. Sri L. Wangshu Konyak, Regional Council Member, is allowed to continue cultivation of the low-lying area which has already been, has already put under paddy cultivation at Tijit. Is allowed. That is only a permit, Lordship. Now, on the basis of this permit, he is saying that he has inherited. Where is the question of inheritance? If he says he has inherited, Lordship, is there any document to show that he has inherited this permit? Is there any order of the government? Now the permit has been transferred to his son. There is no document. The petitioner has never shown any document to show that he has inherited. So the permit dies along with the father, petitioner's late father, Lordship. But under what circumstances, Lordship, maybe of the prevailing law and order situation, maybe the government has been gracious enough to give him 0.6867, which tomorrow we might object also, because that is within my land. Lordship, we have raised objection onto the allotment given by the petitioner to various individuals in our land that we have donated to the government. We have even written to the government saying that if it's not going to be used by the government, we'll take it back. Lordship, may kindly come to my affidavit again. Page 12, Annexure 2, Lordship. The type copy, Lordship, will find it at page 13. We have lodged a complaint. Lodging of complaint against allotment of special permit for a paddy farming within 1,200 acres of Tizit town to Sri L. Wangshu, late L. Wangshu Konyak. With reference to the subject cited above, the undersigned Jaboka Village Council and dignitaries would like to draw your kind attention towards the aforesaid complaint being lodged to your competent authority for your kind redressal of this. That, sir, the Jaboka Village Council has offered, donated free of cost of land measuring 1,200 acres of Tizit town for Tizit town development to the government of Nagaland for the well-being of all. However, it is learned that the surplus of land has been occupied and is under the ownership of one individual, L. Nokmang Wangshu, son of late L. Wangshu, with a special permit being issued by the concerned authority. Hence, for taking this matter very seriously, we strongly condemn and put up an objection against hoarding of land by an individual within the donated land by the Jaboka village. We have given our resentment, Lordship. And keeping in view of our resentment, Lordship, the government has taken the initiative of conducting the special inquiry. And now some certain settlement have come, which we agree to that, Lordship. To some extent, yes, we are agreeable. But maybe with the petitioner land at 0.67, we might have our reservation on that point also, Lordship.
No, you have already donated.
Yes.
You have already donated.
And-
so it's up to the government.
Yes. Now, even the TZ Town Public Union, the next annexure, Lordship, which comprises of the village members of Jaboka also, the union. They have also given a resentment over the illegal action of the petitioner. So, Lordship, under such circumstances, now the issue is very clear. It's only a permit all these years. It's only a permit that does not give the right to the petitioner to own that land or give the titleship to that petitioner, or nor he cannot inherit the permit. That's how submission, Lordship.
Yes, any reply?
I'll just sum up here. Despite all those statements, Your Lordship, the fact remains. I have not made any statement beyond what is on the record. Only the records. If the records go against me,
No, but the record says permit.
Yes,
So can a
so-
permit be
yes,
on
Your
equal
Lordship.
footing with an allotment?
Your Lordship, that
And,
is the-
and can a permit
but then
be
what happened-
inherited?
Yes, but then what happened was, the chief secretary who gave the permit at that relevant point of time, he has specifically written, this is the government writing, not the chief secretary. He is not in his personal capacity, he is writing this.
It wasn't the personal capacity.
No,
No.
Your Lordship, this is as the chief secretary, he is writing it, Your Lordship.
See.
But whatever, Your Lordship, I will just make my submission only on the basis of the report.
Just because a chief secretary has said something will not confer title.
Your Lordship, that is,
Yes.
Your Lordship, I have not made any title, claim to title, Your Lordship. In my petition, I have
basically-
only made specific statements that in 1971, my father was given this special permit. Now this special permit is provisional in Your Lordship. Even the word is clear. It is provisional. There is no time limit.
And another question is whether it can be inherited.
Your Lordship,
Whether the permit can be
subsequently,
inherited.
after he expired, by the letter, by the order passed by the then STO, Your Lordship. Your Lordship, I am only basing my case only on the record, Your Lordship. I have not made any statement beyond what is there in the record. So I'll take Your Lordship to the how government has treated this permit as perpetual, Your Lordship. That is all. I want to place it.
It is a permit only for paddy cultivation. That's
It
all.
is. Now, Your Lordship, in 1975, this is it, farmland at Dizit. This is order dated 29 March 1970. No, sorry, I'm sorry. The order which was passed by the Yes, page 35, Your Lordship. Page 35. The government has all along been upholding the permit. This was in 1975. I was a minor. My father had expired. It is not that my father is still alive here, Your Lordship. Whereas complaint has been received from GBs and Ang as well as public of Yongyu village that Sri Nokzam Konyak, Chief Ang of Jaboka village. That is the present respondent number 5's father, Nokzam Konyak. And Sri Dingbong Konyak, DB, attached to the circle of officers office, Dizit have encroached the land allotted to late Wangshu Konyak at Dizit headquarters, Your Lordship. The language. It is not my word. This is the word of the officer. I have no hand in this, Your Lordship. And this is way back in 1975 when I was a minor, Your Lordship. I will not go beyond the record. I'm not going, I have made no statements beyond the record, and I'm not standing by anything beyond what is there on record. It is very clear. In order to let Wangshu Konyak, and this complaint has been received from GBS and Ang as well as public of Yongnu village. These are complaints raised by a village. And now at district headquarters, and now holding by his eldest son, Sri Lokman Konyak. Government records, yes.
But we have to go by the language of the permit.
But whatever,
So
yes,
that is,
I am admitting that.
Yes.
Language is, but it is also perpetual in nature. It is not just an ordinary permit. This is a special permit. The word is also a special permit, Your Lordship. It is just no normal permit. This is a special kind of permit. Even the title says so. Your Lordship will see here, it is special permit.
But a permit can never be an allotment.
It is not, I am not claiming
it is
beyond
not
what is there.
It is not an allotment.
Just because I am submitting and I am using the word allotment, but then I will only stick to the record. I'm not going to go beyond what is there on record. But here also, in 1975, the officer, the district officer has clearly mentioned it is allotted to my father and it is now held by me. And people are encroaching and they have no right. And these are the so-called donors of the land. Subsequently, maybe after so many years, they may have objected. This happens but once a permit is given and it has been held perpetually for so many years, Your Lordship, at this point of time, now after more than 40 years, to cancel it, when the permit itself does not talk about cancellation of the permit. That is the crux point I want to stress, Your Lordship. Yes, special permit was given. It does not say it is specifically given to him as anything other than a special permit. Because the language is very clear. But it has been upheld by the state respondents. Subsequent officers, it was deemed as given to the petitioner's father. That is my point. And even the Chief Secretary's letter is very clear, Your Lordship. It says that it was given to his father. It was given to his father.
Even without going into all the issues, just looking at the bare permit, see, they donated 1,200 acres. And out of that, such a huge plot of land was given to you. And that also they had given for establishment of headquarters. How is that possible? How can it be allotted to you? Out of that district headquarter, how can a certain individual be allotted?
That also only the record speaks. I am not going to make out anything.
Because that was only a permit for cultivation. That is why.
I will only stick to the record. I'm not.
Otherwise, if it was a normal allotment, it's such a huge tract of land, how can it be allotted?
I understand Your Lordship's question, but the record.
Even going by a common man's, look at it.
I am not going into entering into all these areas because I am only sticking to the record. Record, what does the record say? No, it is not mine.
No.
It is not mine. I may write so many things in different ways. But what
various officers may also say this and that. Because our officials also may not be able to use the right language also sometimes. But the court has to only see the language of the deed, the
so
permit.
Your Lordship will see the Chief Secretary's letter. He is an IS officer. The Chief Secretary's letter is very clear. It was given to the petitioner's father because of his contribution during those initial years, because of his sacrifice. It was because of the petitioner's sacrifice that the land was given, not
allowed
because.
allowed to cultivate. Allowed
Yes,
to cultivate.
but it was given to him, and the son has a right over it. That is what the Chief Secretary is clearly saying. Now, even this court, Your Lordship, this honorable, I am sticking to only these 3 documents, Your Lordship. Nothing beyond that.
No, you have already shown
Yes,
the court's order. You have
but
already shown.
Your Lordship, the learned government advocate has stressed so much on the first 2 lines. Grievance of the writ petitioner in this case is simple. The land in question was gifted to his father. He has stressed too much on this. Now, paragraph 2, the court has gone into the record. Paragraph 2, the court has gone into the record. It is based on the record only, Lordship. Sri L. Nokman Wangshu has filed his writ petition stating that his father, late Wangshu Konyak, a resident of Dizat, was the Vice Chairman of Dizat Regional Council. In recognition of his service given to the government and people of Nagaland, government issued a special permit. See, it is not a petitioner's submission. It was a special permit to him on 29/3/1971, thereby giving him a huge plot of land within specified boundaries. The boundaries of the land are given in Annexure B1, map annexed to this writ petition. It's a pure fact based on the record, Your Lordship. No speculation, nothing, no additions, just records. And this court has held that these records are clearly showing that he has a right. That is my only submission is that I am not going into any other areas. If the government has objected, they ought to have objected it at this point of time, Your Lordship. This is a writ petition and it is now completely over and done with. It has attained finality. No appeal was filed here. They have admitted to it.
No,
Your
all
Lordship.
these paragraphs 1, 2, 3, 4, 5.
Yes.
These are all
Based on the
based on the writ petition.
Yes,
On the writ
and it is
petition.
also on
Whatever
the
the
record.
writ petitioner has
Yes.
said, only that is being reproduced.
Yes. But then here also, the petitioner's statement is that it is not an allotment. It is a special permit. No other language. It is because the record says it is a special permit. But the court has arrived at the conclusion from paragraph 5. It is not the petitioner's submission on which basis the court has arrived at this paragraph 5. And paragraph 5 clearly says that he has a right. And if there are encroachments, then in that case it would be violating the petitioner's right. That is only, my position is only that. The coordinate bench of this honorable court has clearly, after the state respondents have also filed their affidavit, the coordinate bench of this court has clearly arrived at the conclusion that the petitioner has rights and it must not be violated. That is the only case. Otherwise, I'm not bringing out any new case beyond that. And it has to be predicated by this, the Chief Secretary's letter, the initial permit, and then the judgment and order passed by this honorable court. That is the only, my only case is that. No point in going into all this technical, what is the meaning of the word permit and all those things. It is of no importance here, to my case. Because court has gone into it, court has arrived at the conclusion that I have a right and it must not be violated. That is my only case. And the judgment of the coordinate bench holds sway.
The only operative portion in the judgment of this court is that a direction was given for inquiry. That's all.
It is the operative portion, yes, but then the observation made by the court arriving, because if I have no right, the court cannot pass any order, any direction. If the court determines
the
that I
Chief
have a
Secretary
right,
had directed for the inquiry, but since no
Yes.
steps were taken,
Yes.
that's why the court said that the
Yes.
direction of the Chief Secretary should have been complied with.
yes, and the court has also held that I have a right, as simple as that. And then affidavit in opposition has been filed by the state respondents. They have made no statement that this is only a permit, it can be revoked anytime. No, no such thing has been stated. So once it is admitted, then it is admitted. That is my only case. If they had not filed any affidavit and the court had just at the threshold disposed of the case, then that is a different issue. But this is a case where the court has gone into the merit of the case and decided. That is my only position, Your Lordship.
No,
And
no,
the government has, yes.
No, I don't think the court has gone into the merit.
So far as the permits and the orders are concerned, the court has, in paragraph 3 also it has been, all the things have been gone into, Your Lordship.
No, it's the case of the petitioner. That the petitioner is
Yes,
saying
and
this,
then-
petitioner is
yes,
saying that.
And then, in the affidavit, file the affidavit, no, the government has not,
Okay.
the government has admitted. That is the only case. I don't have anything beyond that. So after so many years now, 30, 40, 50 years, 1971, presently it is now 50, almost 50 years, almost, not 60, but in the mid-50s, somewhere in the mid-50s, after so many years to cancel the permit, Your Lordship. That cannot be said to be reasonable, fair, or just. That is my only case.
Was any notice given to the petitioner before cancellation?
No notice. No notice. Only that substantive order which is the cancellation issued by the Deputy Commissioner. That was the only copy which was given to us, to me. And that is if I challenge that, and because that is a substantive order, Your Lordship. The other letters are not substantive orders. It is the order which is issued at the end. That is a substantive order.
No, but the basis also has to be challenged.
Yes.
But still then,
Yes.
notice was not given.
No notice. No notice was given.
This, Your Lordship, the cancellation was done purely on the basis of the report. Your Lordship.
That inquiry report.
Yes. It is done on the, yes.
No
And,
notice was given.
and he is aware. He's aware of the report, Your Lordship. Not only that, Your Lordship, he himself has asked the department to have a sitting. We have done that.
Okay. Heard?
Yes.
Yes, that's all.
That's all, Your
Heard.
Lordship.
May I please, Your Lordship?
Yes.
I'm appearing for respondent number 6 in WPC 58 of 2017, Lordship.
Oh, who is respondent number 6?
Respondent number 6 is the Mongyu Union.
Oh,
The petition has been raised in COP 23 of 2022, Lordship. Lordship, I very limited submission, Lordship. In the year 15/5/11 only, I was allotted a portion of 80 into 80 to the Mongyu Union. And Mongyu Union comprises of about 20 villages coming together in and around Dizit circle.
in WP 58.
58, Lordship. 58 of 2017. I was impleted by order dated 19/5/2022 only, Lordship.
So you were allotted land by whom?
By the government, Lordship. By the government on 15/5/2011, Lordship. A portion of 80 by 80 square feet, just to construct a community hall, wherein the Mongyu Union comprises of about 20 villages coming in and around Dizit circle, Lordship. And so I allotted with a permit number 1106 of 2011, and till today the land is under the position of Mongyu Union through the allotment site permit number 1106 of 11. Now, Lordship, I've just one order to be put into record, wherein in the petition also, the petitioner has also annexed petition 58 of 2017, page number 40, wherein the additional deputy commissioner has passed an order that since the permit is in the possession of Monyu Union, the land is given to the Monyu Union and not to Mr. Wangtun Konyak, wherein the land was permitted by the petitioner. And so, as in my case, if at all the petitioner is claiming I have the permit from the government, so it has become a disputed question of facts as to where to go and address my grievances, Lordship. But as far as the present
If the
position
petition is dismissed, then the problem is solved. Your problem is solved.
Lordship. Just to apprise to the court that the site permit is still intact with the ownership is intact with the Monyu Union.
Okay. Heard Learned Counsel, Mr. Tungpo Pongner for the petitioner. So I've also heard Mr. Mr. N. Angami, Learned Senior Government Advocate for the state respondents. Mr. N. Mozi, Learned Counsel appearing for respondent number 5 in WPC 88 of 2022. And Ms. Apila Sangtam, Learned Counsel appearing for respondent number 6 in WPC 58 of 2017. Stop hearing concluded, judgment reserved.
Obliged.
This